May I plead your lordship?
Yes, one.
My lord, the petitioner was the owner of the truck bearing number OD 04Q6408.
Sorry.
Petitioner was the owner of the truck OD 04Q.
Truck number
Met with an accident.
Met with an accident.
On 13/1/22. On 14/1/22, FR was lost. Thereafter, server were engaged and first the server calculate the sum as rupees 5,51,000.
FR lost, but
51,000.
You approached the insurance company?
Yes.
When did you approach the insurance company?
I have approached the insurance company and the insurance company engagement surveyor.
Just I want to know the date. ସେଥିପାଇଁ ସାର୍ ଲିଷ୍ଟ ଅଫ ଡେଟ୍ ଫାଇଲ କରିବା ବି ସମସ୍ତଙ୍କୁ କୁହାଯାଇଛି। ଲିଷ୍ଟ ଅଫ ଡେଟ୍ ରେ ଆପଣ ଲେଖିବେନି ସେଗୁଡାକ
14/1/22
ଲେଖିବେ ନା ପୁରା କ୍ଲିୟରଲି ସବୁ ଲିଷ୍ଟ ଅଫ ଡେଟ୍ ସିଷ୍ଟମ ସେଥିପାଇଁ ଅଣା ହେଇଛି ପୁରା
ଦିଆହେଲା ପରେ
ଆପଣ ଲିଷ୍ଟ ଅଫ ଡେଟ୍ କାଇଁ ଲେଖିଛନ୍ତି 14 ଇନଫର୍ମେସନ ଗିଭେନ୍ ଟୁ ଦ ଓରିଏଣ୍ଟାଲ ଠିକ ଅଛି।
He has deputed a surveyor who has calculated the expenditure.
Calculate କେତେ କଲା
5,51,438 ଟଙ୍କା। Thereafter, another surveyor was deputed who was calculated.
Why another surveyor? Why another surveyor? You have objected?
No, after reparation.
After repairing.
He has engaged another surveyor who was survey made and they calculated the 4,70,000. But the company.
But after repairing, how the surveyor will assess again?
Some amount has been deducted.
Okay, but maybe you over calculated.
4,70,000 ଟଙ୍କା ଦେଲେ। But the insurance company.
ଆପଣ ନେଇଗଲେ?
Report ଦେଲେ। But the insurance company has paid 3,18,500 ଟଙ୍କା। That is why I have before this honorable court.
What is the ground for giving less amount? Insurance company कौन कौन ground रे से कम देले आपको?
Para 8 of the.
Para 8.
Yes.
They after hearing ombudsman पाखु आपने गले.
आज्ञा.
तो ombudsman कौन कहले?
Ombudsman कहले in the instant case the claimant was paid 3,18,500 but was denied up to 52,000 on the ground that as per the principle of policy condition payment of approximate cause of loss is not given. In this case the tipper cylinder assembly hydraulic kit was bent and led to the upturning of vehicle and consequential damages. The second survey report or third sub-IC states that the approximate cause of loss of failure tipping cylinder while unloading, which is a mechanical breakdown failure and excluded from the perils of policy. I agree with the assessment of argument of the insurance company and find the portal repudiation justified.
What is wrong in this order?
Accident cylinder
sir, accident accident because of your negligence accident ହେଇଥିବ ତାହେଲେ
so how 3,18,000 has been paid? That is not that is the accident. FR has been lost. But 4,70,000
ଆପଣ ପଢିଲେ ଏଟା କଣ ବୁଝିଲେ? The proximate cause of loss is due to failure of tipping cylinder while unloading, which is a mechanical breakdown failure and excluded from perils of the policy.
That is not the condition. Accident ସେଟା ଖରାପ ହେଇଥିଲା. In accident that was damaged. Okay. And the server was calculated the expenditure 4,70,000. But company has paid 3,18,000.
Okay, issue notice to the party in Oriental Insurance Company. Anybody there? Oriental Insurance Company. Here, so you saw a copy on OP number 1 by registered post. List the matter on 15th July. Next.
Item 2.
Item 2.
Lord, I am audible. My Lord, I am audible.
Yes,
Lord,
yes.
I am appearing in this matter, item number 2. My Lord, in this case, yes, my Lord, in this case, actually, the respondent has actually considered the material facts, and it is found to be that he is the negligent, that individual that it is he who tried to run away when the demands were made and breached the terms and conditions of the agreement, sale and purchase agreement of the flat for about 10 times. And only when the amounts were to be paid, then he actually issued the legal notices to refund, asking for refund of the money. Now, it is at this stage, my lord, he playing a victim card went to the consumer forum and district forum, my lord, found in my favor. Then,
You're the builder.
we filed actually, both of the parties actually filed appeal.
You're the builder. You're the builder.
I'm a proprietor, small time builder. And in fact, ever since that particular order of the State Commission, my lord, that is the 5th of July 2022, I'm running after him to pay the money.
Builder mean I didn't understand this. Are you a builder in this case or not?
Yes, my lord, I'm builder. I'm a small time proprietor.
Small time, big time, you are a builder, simple.
Right, my lord. Now here, it is a violation of the Consumer Protection Act when the so-called consumer, my lord, has violated the terms and conditions and in fact never breached in all count. This is actually finding a fact on this by the district forum, my lords, that is of the August 2015. And both parties in a cross appeal approached the State Commission. State Commission in para number 10, apparently it is some sort of a kind of a compromise order was passed, my lord. And 45 days, it has to be 18%. That was never a consent given by me. This is not a judicial order as per se. That is the 5th of July 2022, which actually I'm seeking at a later stage when I actually didn't get this, because the moment I went to the commission asking about first time saying that you please increase the timeline because I'm already giving a DD, another DD, because out of the 18 lakh, I've already paid 8 lakh to the bank directly. The 5 lakh I was issuing the DD ballots in the August month post that particular State Commission order, and pursuant to that, I withdrew it because the respondent is not ready to take that amount of money because he was looking to extend that time for getting 18% rate of interest. So ultimately, what I did is that I withdrew that application, and then I sought the permission of the State Commission, which is at page number. Just kindly have a look at it. The 1st of November 2023 affidavit, which is at page number 70 for a moment. And I sought the liberty. I was allowed to withdraw this application. Then I went to the National Commission, and I reached the National Commission within 4 days. There is absolutely, because the order which we are challenging is of 7th of May to 5th of July 2022, and I approached the National Commission in 2023, and there is a delay.
You notice to opposition from 1 and 2. Why registrar and NCDRC is made a party unnecessarily?
Well, because what I have alleged, Velos, there has been no hearing on this application for conduct.
Registrar can't be made a party.
Otherwise, Velos, I would have not been able to exercise 226 jurisdiction against private party, Velos.
Therefore, if something happens, somebody doesn't appear. So when you are challenging the order of the High Court, are you making a High Court registrar as a party in Supreme Court? No.
No. I
tell why registrar NCDRC will be made a party?
That will be difficult, Velos. Then
registrar NCDRC can't be made a party.
Velos, 226.
Show me one judgment where it's a registrar can be made a party. I'll admit it.
Velos, your Lordship may issue the notice. I'll show that.
No. Show me the judgment. If you are issuing notice against one, so you have to show me notice first. No?
Okay.
Judgment you have to show.
All right, your Lordship may issue to the respondent number 1, and the issue number 2, let it be. Velos.
No. Issue number respondent number 1 is registrar.
Your Lordship,
if I am to issue notice, I am to get satisfied.
Lord, I am saying this. Just my humble submission. I'm saying this. If your Lord says...
You cannot issue notice to registrar of the High Court for some wrong order passed by the judge, or similarly the wrong order passed by the judicial member or the member of the NCDRC. How can you?
Then, my Lord, your Lordship should pass the order in 226 against that order.
No, you have to show me the judgment first. I have to get convinced. I don't know.
I am saying if I will only make the party...
I don't want anything. Just you show me a judgment of the Supreme Court which says the registrar of this can also be made a party for any order, any wrong order passed by the judicial authority.
They're actually not the I'll come back with that, my lord. In any case, if your lordship.
Till that I am not issuing notice. You have to show me that first. Because I have to issue
Lord,
notice,
then
registrar means I have to get satisfied first. No?
That's
So
what I'm
I'm
saying.
fixing
Don't
for-
issue.
Fixing
my-
for
my-
Monday.
my-
Monday, give me one judgment on this.
My suggestion, just kindly bear with me. My suggestion is your lordships may kindly issue the respondent number 2. It's all right, Mullah. Let the private party come, Mullah. And in the meantime, I will definitely, if at all, in the next date, if at all, I will press for the issuance of notice to the respondent number 1. Then I definitely will try to satisfy
So you
your
are not
lordships.
pressing.
Judicial.
You are not pressing for one now.
Your lordships is issuing to the respondent number 2. My lords may, for the time being, issue it to the respondent number 2. If at all, I will press for it. I will satisfy your lordships judicial conscience on the next date.
You cannot issue notice to any judicial authority for any wrong order. If wrong order is
I
there,
agree.
it is appealed.
Thi-
Not
This is
the
one-
registrar can be made party.
Lord, this is only one proposition. I'm only saying this is only one proposition. There is second proposition. The second proposition, the lordship says exercise 226. And that brings jurisdiction.
226 doesn't mean that you will issue notice to the registrar.
Otherwise, how do your lordship
In Supreme Court, we used to file thousands of SLP where
Correct.
if this kind of order are there, Supreme Court used to say defect. You cannot make this. There is a judgment of the Supreme Court, you cannot make them. So give that judgment.
I am conscious of that. Your lordships actually is right.
Then you don't press on this.
Issue to the respondent 2. I mean, that's
Issue
good
not
enough.
press Notice to OP number 2. Returnable on 10th July.
Sure, Lord.
Next. You have any IA?
I have an IA for a stay because that is the execution
Stay for
proceeding.
what? Stay
That's
for?
against the execution proceeding against that particular order, my lord, which is a challenge before my lord. Kindly issue that stay, my lords, against that execution proceeding because that should not be fructified till your lordship is hearing this matter.
Okay, stay. I know. Okay. Next.
So kind of.
Till the next.
So
Next.
Item 3.
3.
My lord, last occasion, my friend appearing on behalf of Canada Bank has taken instruction because it's a old loan of amount of 2005. So I want to closure the amount account. So how much I have to pay by waiving the, he has taken instruction, the penalty.
What is the loan amount?
29,000 in 2005, my lord. And
Now what is the total outstanding?
in 2014, the total amount has been written
14,
up.
sir, 14. Again, 10 years before. 2024 रे कहते.
2,17,000 they have asking for a two-wheeler loan.
You are for the bank.
I am for the petitioner, my
You
lord.
are appearing for the bank.
I am
So here-
with us.
Who is for the other open?
Bank, a lordship last time directed to take.
Who is the bank?
He has taken a.
Canada Bank.
Canada Bank. Your lordship has given, directed to give a copy. I have already given them. Last order was.
Given copy
mentioned.
to whom?
Already last order was there.
Mr. Arupananda Das.
Arupananda no, I was sir କହିଲେ.
କିଏ ଅଛନ୍ତି? କାହାକୁ ଦେଇଛନ୍ତି କପି? ତା ନାଁ ଦେଖାଯାଉଛି ଦେଖିଲ?
Arupananda.
ନାଇଁ?
No.
Name is not showing.
Order taken.
Arupananda Das. Arupananda Das, I have already served a copy. I'll inform next week.
Opposite party Canada Bank, Mr. Arupananda Das is not present before this court. Let this state council be present before the court on the next date of listing, 10th July.
10 July. Yes, my name of the Mr. Arupananda may be reflected.
The name of Mr. Arupananda may be reflected.
Okay.
Next,
Item 4.
4.
Well, in item 4, I am for the petitioner. My lord, has taken time to file counter.
Actually, I thought it is legible copy. That is why I seek 1 week time, so that's
Yes,
that's it.
Yes,
11th July.
my,
The request for run. 5th,
Item 5.
Item 5, my lord, lordship has granted interim bail. The petitioner has surrendered on 22/5/2024.
you have filed the surrender certificate.
Yes, I have to file the surrender certificate.
You have to, you have not filed it.
My lord, I didn't get that.
When
Today
is
we
the-
will send.
When is the period expiring?
But 22/5 he has already surrendered.
Surrender.
Yes.
Okay.
Lordship, may record my submission.
Answer the petitioner, Mr. Commissioner, submit that the petitioner has already.
On 22/5/2024.
5/5/24.
My lord.
Though he has not been able to receive the surrender certificate.
I will file it by
They have received.
2 days.
They have received.
Within 2 days, I'll file.
Okay, he filing the surrender certificate within 2 days from 2 working days.
Lordship, may I keep it to-
Accordingly, but the bail application remains this.
Lordship, may I keep it to 10th, 9th, 10th, any
Accordingly,
day.
the present bail application be listed on 10th July.
My lord. Okay.
Next,
Item 6.
6.
May I please, your lordship? Lordship, petitioner surrender in time, your lordship, and filed surrender certificate. Lordship,
See you matter.
ଆଜ୍ଞା?
ଆଉ ଜଣେ ରହିବେ ଭିତରୁ କାଲି ଯୋଉ ଥିଲା ଦେବିନି
କାଲି ତ reject ହେଇଛି।
your lordship, and IFR extension of time for interim bail, your lordship.
बिल्कुल नहीं, no interim time shall be granted to you.
Maybe not test, yes, ma'am.
No.
Not maybe not test, ma'am.
The extension for the interim bail is I have been filed for extension, I number लिख दो. Doesn't merit a consideration, accordingly dismissed. Next,
Item 7.
May I please, Lordship?
next,
May I please, Lordship?
and the petitioner to immediately surrender as soon as the period is over. Huh? Next,
May I please, Lordship? That's offense section 120B, 395, 397, and 25.1% the Arms Act. Petitioner.
quantity,
Quantity noida
Arms Act, my lord.
Arms Act ଅଛି robbery ଅଛି।
Your Lordship has
Robbery ଅଛି।
granted bail to the co-accused, Lordship. That is in flag F, Lordship.
ନା ନା ଏଥିରେ SCD ଟା ଆସୁଛି।
On which confession your Lordship has granted
Let me
bail.
go through that.
what is your role?
So I was present at
What
the
is
spot.
your role in the crime?
Lordship, I was present at the spot.
Just you are a silent spectator and
No,
suddenly
sir.
police came and took you.
Lordship, page 13, Lordship. On the
What
confession
was
of
your
date,
role, sir?
I was present at the spot because I was called.
Be
Village
truthful.
Lordship.
Don't say here and
Lordship.
there. Truthful.
Yes, Lordship. On the confession
What?
statement, the co-accused Prafullo Mishra, I was.
So what does the confessional statement say?
I was
what does
present
it
at the
say?
spot.
What does the confessional statement say? Please read that.
Assuming the registration order is declared that the accused Prafullo Mishra was apprehended, and on his disclosure, other accused person have been
What is
apprehended.
that disclosure?
That these are my friends, then they are
Then
present at the
let
spot.
CD come.
The Lordship has
That
granted bail to
comes to the
the.
state to obtain
Lordship-
the CD.
Lordship, kindly have a glance at the.
His diary on by 8th July.
Lordship, 1st July, Lordship, other co-accused bail application is pending on 1st July.
1st July. Okay,
Yes, sir.
1st July. 1st July. And let the matter be listed on 1st July.
Lordship, your Lordship has granted bail to the co-accused. Lordship, can-
अरे सर आसु तो सीडी टा देखे को एक्यूज के ग्रांट कली बोली आपन करी बोली माने अछि आपन तो का रोल किछि कहि पारु नांती व्हाट वाज हिज रोल कंफ्यूज होचंती सर लेट द सीडी कम एंड वी विल फाइंड फ्रॉम सीडी
he was present at the spot only. And
सर
that's-
आपन कहि देले मानि
ନା ଦେଖି ମୁଁ ପୁଣି TI parrot ଟା ମଗେଇବି whether he has identified or not।
सीडी आसु देखिबा 302 जण को मारी मराई
Lordship,
या आपन
Lordship, 395 Lordship.
आई वाज स्टैंडिंग
Lordship,
लाइक ए
395.
साइलेंट स्पेक्टेटर मानि
Lordship, 395.
395 हो कोन ला
Lordship, village.
Arms Act ଅଛି ତାକୁ ବନ୍ଧୁକ ଦେଖିକି ତାକୁ ଲୁଟିଯିବ।
395 ରେ कोन अछि पनिशमेंट टा कोन
Life imprisonment, 10 years.
সেটা ছোট ক্রাইম
Lordship.
আছে
But the.
এটা ইউজুয়ালি রেপ ক্রাইম আই থট 302 সরি
Lordship,
Anyway,
But
Lordship,
Lordship,
posted,
হুম
posted,
Lordship, the Prafullo Mishra, your Lordship was granted bail, Lordship.
Huh?
Lordship, Prafullo Mishra, the accused on whose confession statement
হুম
they are apprehended, your Lordship was granted bail, Lordship.
let them
Let me
get
say.
let them get
ମତେ
that.
ଗୋଟେ କପି ଦିଅନ୍ତୁ।
let them get the CD CD आला पर
ନାଇଁ।
Lordship, 1st July.
8 July,
Lordship,
8 July,
Lordship,
First.
1st July কে আছে স্যার আরটা
Lordship, 1st July, Lordship.
1st July তো 1st July
Item 8.
May I please, Your Lordship?
It's an
My Lordship, I'm
item
on behalf
eight.
of Mr. My Lordship, I'm on behalf of Mr. Rajesh Mahapatra. My lordship, due to the sudden demise of her mother, he is unable to attend the court today. So I seeking an adjournment on behalf of him.
But I am there on behalf of Mr. Sarangi. He has
He
also
agreed
requested that the
She's asking for some time.
But I have no objection. It was, in
Then what
fact,
are you
the petitioner was also seeking time
Oh.
because the legal aids were,
You are on the same page.
yes, Mr. Sarangi requested me that he needs some time to file the,
Okay, ठीक है. So when do you want?
should may keep it after 14 days or 15, 2 weeks after.
15th July.
I'll inform
Oh,
Mr.
yes, my
Sarangi.
lordship.
ସେ କେତେ ଖୁସି ଦେଖୁନ ଟାଇମ ନେବା ପାଇଁ ସମସ୍ତେ ଖୁସି ଆର୍ଗୁମେଣ୍ଟ କଲା ମୋ ଏମିତି ହେଇଯାଉଛି okay next
Oh, bless
next
my
time
nine.
to argue the matter
Nine.
you
Yes, my
are
lordship.
smiling a lot today na because for the adjournment seeking advocate you are today you must argue the matter
Oh,
next
bless.
Like in this case, I am for the petitioner. Lordship, kind of last order dated 6/5/2024.
hmm.
Order dated 6/5/2024. Last order.
What is the matter
The matter is yeah, the suppression. He had taken a policy mailor. I am for the LIC mailor. He had taken a policy suppressing the real age mailor. The age
what is the age
different.
what is the real age and what
The
is the suppression age
Suppression mail in the LIC, Lordship can see the in policy bond. He has written the date of birth that as per the well, the Aadhaar card, the difference 16 years. The LIC in a policy that condition is
LIC वाला को date of birth को आपण
ଆଜ୍ଞା ଯାହା କହିଲେ ତ ଡେଟ୍ ଅଫ ବାର୍ଥ ଯୋଉ
ଆଧାର କାର୍ଡ ଲେଖା ହେଇଥିବ ସେଟା
ଗୋଟେ
ଆପଣ ନିଅନ୍ତି
that
ନା
is ମାନେ 16 years difference.
ରୁହନ୍ତୁ ନା ମୋ କଥା
ଆଜ୍ଞା ଆଜ୍ଞା
ଆଧାର କାର୍ଡ ରେ କୌଣସି ଜାଗାରେ ଆଧାର କାର୍ଡ ଡେଟ୍ ଅଫ ବର୍ଥ କୁ ଡେଟ୍ ଅଫ ବର୍ଥ ଧରା ଯାଏ ନାହିଁ
ସେ
LIC ବାଲା କେମିତି ଧରୁଛନ୍ତି ଆପଣ
ଆଜ୍ଞା
ଆଧାର କାର୍ଡ ରେ ଆପଣ ଯାହା କହିବେ ସେଟା ରେକର୍ଡ ହେଇଯାଉଛି
self declaration, that is self
ସେଲ୍ଫ
declaration.
ଡିକ୍ଲାରେସନ ନା
Self
ତ
declaration.
ସେ ଆଧାର କାର୍ଡ ବହୁତ ଲୋକ ଗାଁ ଗହଳି ଲୋକ ଜାଣନ୍ତିନି ତାଙ୍କ ଡେଟ୍ ଅଫ ବର୍ଥ ପଚାରିଲେ ଜାଣନ୍ତିନି ପଚାରିଲେ ଜାଣିପାରିବେନି ସେଲ୍ଫ ଡିକ୍ଲାରେସନ ଆଧାର କାର୍ଡ ରେ ଭୁଲ ହେଇଛି ଏଇ ଭୁଲ
ଆଧାର
ହେଇଛି
କାର୍ଡ ଭୁଲ ଅଛି କାହାର ଡେଟ୍ ଅଫ ବାର୍ଥ 6 ମାସ 2 ମାସ କି ବର୍ଷେ 2 ବର୍ଷ
ତାପରେ କେମିତି
that is
ରାଇଟ୍
16 years. ଆଜ୍ଞା
କେମିତି
subsequently
କୋଉ
subsequently
ବେସିସ୍ ରେ ଭେରିଫାଇ
investigated as per investigated and they have obtained
ହେଲା ଯେ ଇନଭେଷ୍ଟିଗେଟ ଗୋଟେ ବେସିସ୍ ତ ଥିବ ନା
ଆଧାର କାର୍ଡ ବେସିସ୍ ରେ
ଆଧାର କାର୍ଡ ବେସିସ୍ ରେ
ଆଧାର
ଆଧାର
ଆଜ୍ଞା
କାର୍ଡ
16 years 16 years
କୋଉ ବେସିସ୍ ରେ କଲେ ପଚାରୁଛି 16 ଜଣ ଜାଣିଲେ କେମିତି
local inquiry କଲୁ ଆଜ୍ଞା
ଲୋକାଲ ହେଲା କେମିତି ତାକୁ
ଗୋଟେ
କାହାକୁ ପଚାରିଲେ ଯାଇ
ପାଖ ପଡିଶା ନିଶ୍ଚିନ୍ତ କହିବ ତାଙ୍କ ଏଜ୍ ରେ ଆକ୍ଚୁଆଲି ଏଜ୍ ନା 6 ମାସ ବର୍ଷ ଡିଫରେନ୍ସ ହେଇଥିଲା ଯେ 16 ଇୟର୍ସ ଡିଫରେନ୍ସ କହିବେନି ଆଜ୍ଞା ତାର LIC ପଲିସି ରେ maximum age is 50 years at the time of taking a policy the age was 63 but he has mentioned that is 47 that is the sole ground
ଝୋଲ
ଯାହା ସେଲ୍ଫ ଡିକ୍ଲେୟାର କରିଦେଲେ ହେଲା
any issue notice
Yeah, issue 2017 matter. I am for the petition. 2017 matter.
total
Okay.
2017
2017
Who is for the
matter.
opposite
Actually,
party?
the case was filed in 2016 before the
who is for the opposite party
Fresh note, no, fresh notice was issued last
You are
order.
here for the
I am for the opposite party. Then, my lord, what happened?
D then now you are not
Not.
who is
That's why your lordship issue notice.
who is then opposite
ସେଇଟା
party?
କିଏ ଗୋଟେ appear କରିବେ ଆଉ କାହିଁକି ନା ସେ lower court advocate already died.
ତାର
That's
ତ
why.
ଆପଣ ଛାଡୁଛନ୍ତି ମାନେ ତାର ତ ପକ୍କା
ନାଇଁ ନାଇଁ notice ଟା କରିଛନ୍ତି last order your lordship କାହିଁକି last order ଟା
ଦେଖ,
last order ଟା
last order is submitted
no-
the conducting out a lower court advocate. He is an expired. He is unable to contact. For that reason, the lordship direct.
direct issue notice to the
Can I
opposite
play one
party.
thing, my lord?
Rest is a notice ଟା କଣ?
ସେ ଦେଇନାହାନ୍ତି requisite ଟା file କରିନାହାନ୍ତି ବୋଲି ଯାଇନି
Requisite. Requisite is key.
petitioner
Can
file
I play?
କରିବ
Can I play one thing, my lord? Yeah, lordship direct to local police so that take instruction whether they will intimate the matter as in list of fixed on so and so date. So the matter can be solved.
ଏଇଟା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ନାହିଁ ମ୍ୟାଟର ଲୋକାଲ ପୋଲିସ କେମିତି ପୁଣି
Government advocate ଅଛନ୍ତି
advocate କେମିତି
ଆଜ୍ଞା notice ଯୋଉ ପୁଣି ଫେରିବ
advocate କେମିତି ରିସିଭ୍ କରିବେ
ଆଜ୍ଞା
କି କଥା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏଥିରେ ପାର୍ଟି ନାହିଁ advocate କେମିତି ରିସିଭ୍ କରିବେ
That's why your lordship issued fresh notice was issued by your lordship.
let fresh notice be issued to the opposite party by registered post by way of or the petitioner may choose to go in for a paper publication.
No, condemn the in the lower court, not in this court.
He is out of the murky business. Next,
Item 10.
10.
Lords, on the last occasion of hearing, your lordships wanted to know if TPCODL can be as a
yes,
state, there is
yes.
a judgment of this honorable court which has taken
Mate
into.
Supreme Court judgment darkar. Ei judgment
No,
mu
it
dekhi
has
tarchi
taken,
analysis nahi se judgment re.
no, it has taken into account all the decisions of
mate
the
Supreme
Supreme
Court
Court.
gote dekhantu. Bhallo judgment Justice Pardiwala रे gote judgment Gujarat High Court रे
Yes, my
achi.
lords.
ଆଉ Supreme Court ଦୁଇ ତିନିଟା ଭଲ ଦେଖାନ୍ତୁ
All right.
କାରଣ ଏଥିରେ ଅଛି ଜଜମେଣ୍ଟ କୋର୍ଟ ଗୁଡାକ କରାଯାଇଛି ଆନାଲିସିସ୍ ନାହିଁ
All right. I'll give my
ପଢି
lord.
ସାରିଛି ଅଲରେଡି
I'll give it.
ଆଉ ଗୋଟେ କେସରେ ବି ମୁଁ ସେଇ ରଖିଛି
Number of
Gujarat High Court Justice Pardiwala has written a beautiful judgment about 90-100 pages
100 pages.
beautiful
Yeah, I've gone through that.
so get that judgment
All right.
and prepare a note of that judgment. Okay, tell your junior to prepare a 5 pages, not more
There's
than
already a factual note there on record. So far as the issue of law is concerned, we'll prepare another small.
that. On law, I'm saying.
Yes,
That note on that judgment only.
all.
Small 5-pager note, okay? 5-pager is not small. Still, I'm saying small. Okay. Next.
Your lordship, but keep it sometime in.
So when?
As your lordship's second week of July, maybe after 15th, any date.
After 15? 16? 16?
60.
Okay. Next.
Obliged.
Next.
Item 13.
13.
It's on behalf of Mr. Mahapat Brahma permitted. The last occasion was a Lordship may see 23/4/2024 order.
What is the case?
But the case is regards to the insurance which was given to the opposite party number 2.
You are for the insurance company?
Yes, my lords. I am for the petitioner, that is the insurance company where a permanent Lok Adalat order has been challenged.
What is the order of permanent Lok Adalat?
Plus the order of the permanent Lok Adalat is at annexure 1, your lordship may see. He has given the insurance which was there on behalf of the opposite party number 2, stating that on the grounds that he was eligible. But on behalf of the petitioner, which is the insurance company, we have challenged that order on the ground that he has
Tell me,
suppressed
what is
the fact
issue
that
from the beginning, sir.
he had
What is
suppressed,
the issue? What is the
he
issue?
has suppressed the disease which he was going. He was a
So what are the
chronic
diseases he
kidney
has suppressed?
patient, my lord.
Please don't talk. Please. Please. What are the diseases he has
He was a
suppressed?
chronic kidney disease patient, which he had
CKD.
suppressed.
CKD.
CKD, which he had suppressed, and he was also belonging to
How
the.
does the insurance company know that he has
Well, it's
suppressed?
after the investigation started, it has come up to the light. Therefore, your lordship had issued notice.
CKD for how many years?
Lords, it was there for a considerable period.
Before the
Yes, my lords.
the policy was taken.
Policy was taken.
Okay.
And your lordship had issued dusty notice also.
He not come.
By the order dated 16/11/2023, and by last order, your lordship had granted last chance to the opposite party.
Your
Otherwise,
lordship also
the matter will
directed
be.
Mr. Moon to serve a copy through local police station. We have
Sir.
served and it has been sufficient manner. She has received on 22nd March 2024.
Still nobody is coming. This minor girl is there, so maybe there is a problem. The 17-year-old girl, she is representing the grandfather who died. So maybe there is a problem because of a small girl. I don't know how it is.
That's if I may propose, if the local IAC, with the help of the legal aid council.
But that is, I
And-
mean,
Already served, my lord.
already served.
Yeah,
Sir.
my lords,
Service.
she might not
Good day,
be
good day, good day.
aware of the legalities, my lords.
He's my lord friend saying that through local police station, if
Along with the
cooperation-
legal aid council from the district, if she may be made aware of what is happening.
Okay, like the since the opposite party is a minor girl and has not appeared for this court in person or through advocate, despite there is a despite service is complete in our favor. Kalahandi, this is Kalahandi.
Again, Gonjam.
Ganjam.
Gonjam.
Which place?
Well, it is written at post Alia Goda, PSB Sadar, Ganjam.
Aladi Gada.
Already got it.
A copy of the writ petition may be served on the District Legal Service Authority, the Chairman District Legal Service Authority, Ganjam, who in turn shall take steps to get it served to the local police station and also takes reasonable step so that the opposite party, the sole opposite party, who is a minor girl, can be made aware about the case, and accordingly, the District Legal Service Authority shall extend a helping hand to the respondent, sorry, the opposite party. List the matter on 6th August. Okay. Let's see,
Grateful, my lord.
another attempt.
But I believe that is the best possible.
Because it's a minor girl, we should have.
Yes, my lord.
Okay. And a free copy of the order may be sent to the District Legal Service Authority along with the writ petition. Extra copy to the.
Again,
Huh?
I'll serve it to my learned.
Through registry, through registry.
Registry वाला को कही दे से खाली चिट्ठी पठे दोछन्ती आ से कोन अछि काउ के जणा पड़िबनी. That is what they are doing. Easy काम ना चिट्ठी पठे देला सहज से कोन गोटे संबलपुर गोटे इंजीनियर कमिशन अपॉइंट करनी. इंजीनियर कमिशन टोटल फाइल देबा कथा हम रजिस्ट्री बाबू माने कोन कहछन गोटे लेटर टे देछि से कोर्ट की जीवो कोन एसेस करिवो केमती एसेस करिवो पॉइंट ऑफ रेफरेंस कोन तो ऑर्डर कॉपी भी देई नाहंती 2 मास हेलानी. Yesterday the matter was listed. See time मागी छंती. Then suddenly I somehow got the number and I called him. भाई 2 मास हेलानी आपन अपॉइंट करी कमे देई नाहंती. He saying sir मो पाके तो फाइल ही आसीनी. लेटर टे आइला आपन को अपॉइंट करा गला. मैं अपॉइंट करा गला मैं कोन करबी मते जाना नै. मु कोन करबी. So this is the problem. So registry वाला को एमती जदी कॉल वाला से तर चाकरी पड़ेबो. जी सिग्नेचर करबी. सीधा गुड कॉपी टे तक काई देलेनी. आज से लोक को नहीं गया खराबे नहीं गया से जे पठेई जी से लोक सस्पेंड करा हाले छड़े ए लोक 2 मास गोटे लोकर घर एंती भांगिया के बसिलानी कमिशनर आसबे. So tell the registry guy to send the copy along with send the letter along with the this copy of the writ petition. Give copy. Let's move on. Next.
Item 14.
Next.
My lord, I shall file the requisites by Monday.
Sir, 2023 रे मैटर आपण रिक्विजिट एबे फाइल करछली 2023 मैटर
24 matter.
कोडा एटा केते नंबर की
14 matter.
केबे फाइल कर नोटिस केबे इश्यू दिला
Notice 16/4/2024. madam.
4 हेलानी एबे आपण नोटिस इश्यू करछी
By Monday, madam.
petitioner 6 1 week time to file the requisite. Next.
Item 15.
Out of standard लिख दिया.
May I
If
please
the
allot, sir?
requisite file is not filed within 1 week, the matter shall automatically be dismissed without reference to the court. Like the line.
May I please allot, sir?
Next.
My lord, due to typographical mistake, the father's name of the petitioner number 1 has been wrongly mentioned.
दे दियंतु एटा केते फाइनल कर देला.
कुहार लोहरटा
आगुआ तो लिखि दे आपण पेंसिल टिके कर दे दो.
my lord, problem.
जो जोटा मिस्टेक हे जो सेटा काटी दे पेंसिल लिखि गुटे कॉपी दे दे.
आज्ञा,
कर दो हला एबे संगे संग अरे लेके दे दियंतु संगे हला. Next.
Item 17.
17.
May it please, madam. Lordship, this criminal revision has been filed challenging the order of the learned additional sections and district judge Nuapada, wherein the order and sentence sentencing the present petitioner to 3 years rigorous imprisonment for offences under section 307 read with 34 has been confirmed, madam.
कौन कले आपण? What is your
My lordship, the
role in the crime?
the prosecution case is that the petitioner and another person assaulted on the night of 22
Assaulted by way of
allegation है 22/4/2013 रे they went to the house of the PW1 who is the injured informant my lord. Thereafter they knocked on his door asking for some bhang.
Bhang.
Yes my lord. Tapare PW the co-accused allegedly held him from behind and the present petitioner assaulted by way of a brick and a lathi. The mode of assault is not borne out clearly in the course of the trial my lord. And that is the ground on which I humbly challenge the confirming judgment of the learned appellate court, my lord, that the evidence has not been appreciated in the proper manner.
Okay,
And
admitted.
my humble.
You are in custody?
Yes, ma'am.
You are inside custody?
Yes, my lord. The co-accused has been released in bail. ma'am.
Since when?
Since 2022, ma'am.
2022.
Yes.
So total, the.
Sentence is 3 years. In the meantime, I have served almost 2 years of the sentence.
Yes, yes.
Yes.
Granted. Subject to plantation of 50 saplings in your village area. Koga?
এটা নোয়াপাড়ারে my lord.
Noapada town?
নাই নোয়াপাড়া গাঁ।
So you Noapada गाँव नहीं हो? Town.
নাই নোয়াপাড়া
District
ডিস্ট্রিক্ট
headquarters?
গাঁ।
वो गाँव कौन?
বুখরা বস্তি পড়া গাঁ।
Basti pada, Noapada town.
Outskirts.
Oh, you will plant saplings in the government land / in the order of 50 taka chala gaye.
Oblige.
And you will take care of the plants for 2 years.
I'll do the next.
And the local police will monitor that in coordination with the forest department.
Yes, my lord, because se gach lage debo gai phai khai dele se
ଆପଣଙ୍କ ଦାୟିତ୍ୱ ଗାଈ ଖାଇଦେଲେ ଗଛ ଲଗେଇ ପଳେଇଗଲେ ହେଇଯିବ 2 ବର୍ଷ ଆପଣ ନେବେ
ଖାଲି ଫରେଷ୍ଟ ଡିପାର୍ଟମେଣ୍ଟ ର କୋଅପରେସନ
ନା କୋଅପରେସନ ଆପଣ ଗଛ ଲଗେଇ ତ କଭର ବି ଆପଣ କରିବେ
Yes.
ହଁ ସବୁ କରିବେ ଆପଣ
lordship he is adivasi local will be more than happy to
ଗଛ ଲଗେଇବ
ସେଥିପାଇଁ my lord so he will be more than happy to indulge in this direction
very
from
good, very
honorable
good.
court.
Let your tribe increase. Okay.
ଖାଲି ଫରେଷ୍ଟ ଡିପାର୍ଟମେଣ୍ଟ ର ଟିକେ କୋଅପରେସନ ରହିବ
Cooperation ସବୁ ଲେଖା ହବ not
Yes.
order.
lordship delay ଟା ଅଛି that
କେତେ delay?
2 ବର୍ଷ se because of
What delay
financial
gone?
hardship
Because what is the profession of this man?
he is a farmer my lord
Okay.
farmer
He is agricultural laborer mu likhi diyo na
Yes.
agricultural laborer and he was not aware of the about the progress in the pool lack of communication.
much obliged.
Next.
Item 18.
18. Huh? 18. कौन है सर 18
This my lord, I am appearing for the petition of my lord.
पिटिशनर कौन है
While the counter affidavit, I don't know if he has received or not because my record doesn't show anything. I don't know if it might have been served. If not, I'll just give him a copy.
give him a copy.
Let him know.
Learned counsel for the petitioner seeks to file the rejoinder. 11th July. File your rejoinder whatever. Don't ask for further time. Final hearing ke rakh dena. 2015 matter. Place it for final hearing. No party shall be granted any further time. If any party seeks time on the next date of listing, the party shall saddle with an exemplary cost. Next.
22.
22.
My lord, on behalf of Mr. Tripathi for the OP party number 3, I am praying for an passover. As Mr. Tripathi is on his-
Passover.
Yes, obligement.
Next.
23.
23.
The opposite party.
23. Petitioner ke
Petitioners ki
SN Sahani.
expired years. Napoleon, sir. Napoleon has expired. Napoleon, yes.
Tankar junior to civil ki.
Thiba katha, but we have already paid. That is why possibly they are not in.
Kaviraj Pradhan. He appears yesterday he was there. Kaviraj Pradhan would matter my quarter.
We already paid the amount which he has claimed. We already paid since 2017.
He paid.
Possibly high, yes.
So should I record his statement?
This
is what?
Gratuity has been paid on 24/10/2017, amounting to rupees 20.
Kodi achi.
Again, no more file koreni, more on instructions I am submitting.
Can you give me?
Mu dei dibi.
Just go to
Lekhi ke dei dibi, sir.
I'll
Lekhi.
pass.
Yes, yes. I'll-
ଏବେ ଦେଇ ଦିଅନ୍ତୁ
ହଁ ଦେଇ
ଟିକେ କାଜ ଲାଗେ
ଗୋଟେ ପ୍ୟାଣ୍ଟ ଗୋଟେ ଦେଇଦିଅ
କାଜ ଫର ଦ ଅପୋଜିଟ୍ ପାର୍ଟି
କାଗଜ
ପାର୍ଟି ନମ୍ବର କେତେ ଆପଣ
ଟୁ ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 2
submit sir submit that the opposite party has already
petitioner has been paid, your lordship.
petitioner has been paid
Well.
the sum of rupees how much
9,36,498.
9,36,498
Yeah, 58. Sir, 58. That is
58
58. On 24/10/2017. Yes.
the cause of action no cause of
Survives.
accordingly the petition
लिखी की चीज़
disposed of
लिखी दे दीजिए Grateful.
next अब फिर दे दी तो टिक के लिखी दे
आगे हाँ लिखी दो
टिक के भूलभाल ना हो
नहीं लिखी दो
next
Item 24.
24
After my lord, Mr. Manli could not pick up the matter, my lord.
ticket the best thing you are general candidate or SC candidate
I'm a SC candidate.
you are SC candidate so you have I mean you are found in the selection list you are in the SC category
SC candidate.
right then
Total 22টা হচ্ছে 17টা হচ্ছে UR category, 4টা হচ্ছে SC, ଗୋଟେ হচ্ছে ST. ଆମେ ହଉଛି 5
problem ଟା କଣ ତାହେଲେ
ସାର୍ ପ୍ରୋବ୍ଲେମ ଟା କହୁଛି କଣ ଟିକେ ସାର୍ ଗୋଟେ ମିନିଟ କହିଲେ ଜାଣିବେ এই ଯୋଉ UR category ଯୋଉଟା ସିଲେକ୍ସନ ହେଲେ ସେଥିରେ 5 ଜଣ SC କ୍ୟାଣ୍ଡିଡେଟ୍ ଥିଲେ ତ UR ସିଲେକ୍ଟେଡ ହେଲେ ତାଙ୍କ ଭିତରୁ 5 ଜଣ ହଉଛନ୍ତି SC ଆମେ ହେଲୁ ତାପରେ ହଉଛି 4 ଜଣ ହଉଛି SC ରିଜର୍ଭ ବେଟର ମାର୍କ ରଖିଥିଲେ ବୋଲି UR ରେ ରହିଲେ ଆମେ ଟିକେ କମ ମାର୍କ ଆମେ SC କ୍ୟାଣ୍ଡିଡେଟ୍ ରେ ହେଲୁ 4 ଜଣ ସବସିକ୍ୱେଣ୍ଟଲି କଣ କଲେ से 5 SC कैंडिडेट बाहर कर देगी जो ऊपर जो UR कैटेगरी जो 5 जन थिले से 5 जन तो कहले ये जो 4टा पोस्ट अछि 4टा पोस्ट से रही टोटल 5
ମୁଁ ବୁଝି ପାରିଲିନି
सर UR सर टिके कहूची UR कैटेगरी 5 जन SC पाइथिले अधिक मार्क रखी की सब्सिक्वेंट नोटिफिकेशन रे कोन कले से जो 5 जन पाइचंती SC कैटेगरी रे SC कैटेगरी नो SC UR रे SC जोड़ा पाइथिले ताको सब बाहर कर देख सेठू ताको भीतर ऊपर
से पिला को एसी कैटेगरी दे देले
हां सेही ऊपर 4 जन जाक ऊपर 4 जन को एसी रे रख देले तेन ता भीतर 5 जन रो आउ जणे आ ये 4 जन को बाहर कर देले तो सेउडा हला सब्जेक्ट मैटर चल
मैड्रास हाई कोर्ट कोन कहले
मैड्रास हाई कोर्ट कहले जेहेतु रिजर्वेशन रिजर्व पोस्ट UR कैटेगरी रे रिजर्व कैटेगरी कैन कम्पीट so their selection justified in UR category.
Okay.
तेणु जो माने SC कैटेगरी रही छथि they will remain in SC कैटेगरी जे रिजर्व कैटेगरी
that means there will be status quo ante
my lord
that is what status quo ante जागरो हितला सेटा माने रेन्यू होचे that's what मालरे से गुड
सर
then what happened
सर एथर कोन कर बाहर कर देल जोटा का बाहर करके जो 17 जन रु
सर तापरे मद्रास हाई कोर्ट कहला पर सेही केस रे कोन हेते तापरे
सर मद्रास हाई कोर्ट करथिले माय फ्रेंड इज सेइंग दैट दे आर फाइलिंग रिट
कोन हला मद्रास हाई कोर्ट से ऑर्डर कोन हला
से तो तांसु कहले कल सेमान पाइबे बोली कहले देइथिले आई हैड सप्लाई
सर गोटे सिंगल जज कहला तापरे डीबी को जाइथिबे सुप्रीम कोर्ट कोन हला पतर
सिंगल जज रे हेइथिला माय फ्रेंड इज सेइंग दैट दे हैव गॉन इन रिट अपील मद्रास हाई कोर्ट
सिविल कोन कहला
माय हेइनी सर हेइनु पैसा
अपील जाइछन सिंगल जज ऑर्डर देंदो से ऑर्डर कर दे आपण अपील
देइछि कॉपी देइछि नहीं सर सेटा
खाऊ ना ऑर्डर पास कर दो जी आपण सुप्रीम कोर्ट जिबे असुविधा कोन ला
जजमेंट देइछि
सुप्रीम कोर्ट गवर्नमेंट पैसा
देखियो जजमेंट देइछि
कोन
मद्रास हाई कोर्ट जजमेंट
ऑर्डर टा
सर दउछि
मद्रास हाई कोर्ट सिंगल ऑर्डर देन सिमिलर लाइन टा मु पास कर दियो ऑर्डर एक्चुअली मद्रास हाई कोर्ट
जजमेंट
नहीं आपण कोन पे चेंज कले हटात रोन तो मते गुडे आंसर देंतु जणे सिलेक्शन हेतिला आपण तो सिलेक्शन कॉलेज जाई पारिबो सेथरु इफ द यूआर कैंडिडेट आई मीन दे कैन compete with the UR candidate and they can accommodate in UR category then why did you suddenly change your stand
that's why I'm
without saying the paper tell me why did you change your stand
Solicitor General made a statement in a contempt of.
Sir, कौन के statement देले मो पचारने मोदे answer दियंतु. Why did you change your stand abruptly? कौन पाई?
The basis of the litigations arising in all over the country. This issue has been challenged before the Honorable Supreme Court that the Supreme FC category cannot be promoted to general category. 2010 notification
Now that Supreme Court matter is pending before the Supreme Court. Which case? Just a minute. Which case?
I'm giving the case number. It's the kindly come to page 9 of my counter affidavit. The detail that I have mentioned.
Page 9.
Counter affidavit page 9.
Supreme Court केवल लगी थी इस matter टा?
Sir, ओटा dispose of ହେଇଛି ମୁଁ ଦଉଛି judgment ଅଛି କୋଟେ କପି ଦେଇଛି judgment. The judgment I have given ଅଛି ମୋର ବହିଟେ ଅଛି.
Number कौन तो मुझे देखी थी भी?
4831.
Just a minute. Just a minute, madam. Take care of you.
After that, the aforesaid content petition number 314 of 2016 in XLP number 4831 of 2012 is presented. Came up for hearing on 29/9/2016. In follow-up of hearing of the above mentioned contempt case, Shri Ranjit Kumar, the learned Solicitor General of India, by his letter number second such, has communicated and advised MO Railways as under.
You're right. But in the Supreme Court, you have government has stated that they are not giving such kind of this permission. Therefore, so rightly they have.
I will not be deprived. If that will be decided in their favor, they will again be.
So let it be decided. Otherwise, I can't decide. It matters. Matter is pending before the Supreme Court. I can't decide this. Let the Supreme Court come up with something. Finally, what?
4831 ଟା जोटा कहउचंती सेउटा तळ कॉलेज जेतळे नोटिफिकेशन बाहर करथले सेटा किंतु टैग हेची अलग विथ गोटे बैच ऑफ केसेस 5 जज बेंच गोटे पठाला.
Sir, ए 5 जज पठाला इतने नहीं मोर फाइनली मैटर टा डिसाइड हेनी ना. Finally matter is still pending before the Supreme Court. ये इशू पर डिसाइड है ही नहीं है. So that's
Similar case के entry order pass है कि state
let it lie over for some time. 29th August लगे दे. Let's see. Because this issue, if I decide something, Supreme Court decides something, there will be definitely unnecessary problem. So next. 25.
I'm appearing for 459.
459. Like 459. ठीक है. क्या बा डेट चला next निकला?
1st of July.
1st July sir. Next. Yes.
Item 27.
27. 27.
Your Lords.
What is the matter about?
Regulation as a clerk in municipal corporation matter. As a junior assistant.
In municipal corporation?
Cutter. I was appointed sometimes in 90s.
90s.
As a skilled worker in different capacities. Ultimately, I was shifted to library as an assistant. Now, my lord, I approached this honorable court earlier for regularization other aspects, and that was considered pursuant to an.
Who is appearing for the municipality?
I'm for CMC.
Please sit. Let him complete and I'll, sorry. Yes.
I was before this honorable court earlier also. Now, your lordship, the
Earlier he came, what happened? Representation dismissal.
your lordship, no, directed to give effect to the recommendation made by the committee constituted by meeting of the selection board constituted on 20 April 2000, sorry, August 2014.
What is your problem actually?
My problem, instead of appointing me as a junior clerk, they have appointed me as an attendant. So my name is as an attendant.
Attendant.
Yes. So
What is the difference between the scale between the two?
More than 12, 13,000.
So you are saying since you have been recommended to be appointed as what is that junior assistant. Instead, you have been appointed as attendant. Okay. That is your grievance? Okay, why did you do that, sir? Come directly to the point.
They say in the counter affidavit
Hmm.
that I could not produce the document of my engagement.
Engagement.
I was engaged by you, not by a foreign body, your lords. I was engaged by them. Now I have been appointed, the next year one, that is what, junior assistant in place of, sorry, the next year two.
So if you have given this appointment, you must be having your record, na?
My lord, actually petitioner was initially engaged as a daily wages basis as
Fine,
a
but later you
attendant, my
regularize.
lord.
Later you regularize.
No, my lord.
Oh, but even then you must be having some record.
But
Yeah,
the
we
question
have
of the record
already-
doesn't arise, your lordship.
Still, even if it arises,
Committee considered my case and recommended.
fine,
That is why I am saying.
fine, but
As
still,
per
you must
instruction
be
of the
having some
government, my lord,
records,
we
sir.
sent.
In your office, it can't go just like that. कि बिना record office चले आपनकर. Municipality office गुटे चालुची बिना record. गुटे employee केतेटा अछंती कोन तार तो किछि तार हाजिरी नोतिबे किछि त थिबो.
Yes, yes.
आ फिर किने record पर नाही बोली कोन.
And at the time of inquiry, my lord, he has not produced the relevant documents.
ठीक है जदी कर न पाला सी मैंने छोटा मैनुअल वर्कआउट से ता पाखे नतला भी आपन को पाखे तो अछि ना.
There was a serious allegation that
What is that serious allegation?
allegation about that some fraud has been
What kind of
committed
fraud,
by
sir? Tell us.
the list of total number of 144 number of employees list was sent to the government for regulation. But
Including his name.
yes.
Okay. Then what kind of fraud? You are saying fraud, na? What kind of fraud? Just like don't say anything.
The petition was submitted by the one Pralaya Anti-Corruption Committee, my lord. Jhola se Bakshi Bajar, cut before the commissioner, secretary to government.
Anti-commissioner committee. Anti-corruption committee. Who is it? Government body? Is it government body or self-style? Self-style.
Yes.
Yes, yes.
किए corruption को body लिखी देला चिट्ठी हेगला बिना inquiry रे बिना ये रे
government को सेटा जणाइले.
In para 4 of the counter, a committee was formed. My lord, come to para 12. And he has not given a rejoinder to it. As reported, committee was formed by the CMC and inquiry was made to the aforementioned allegation, and the inquiry report was submitted to the Housing and Urban Department, Hyde Office Order. Further, it is also reported that time of inquiry, the petitioner was failed to produce the document regarding his original engagement. So also any order regarding assignment of work as NMR. However, in the department qualification role prepared by CMC shows that he was engaged as an attendant and attached to CMC library. And accordingly, earlier his name was recommended to government department for.
So what the government recommended his name for attendant, not for.
Yes, as he was working there because he couldn't produce anything. And this is a.
What are the document required to be produced?
The engagement time is your document देबे. सब पूरा inquiry हल्ला करो.
What is his qualification?
My
what is your qualification, sir?
I don't know.
You don't know. क्या बात कर रहे हो? You are
mass
appearing,
fraud was conducted.
You are appearing for your client and you are.
Made regarding fraud, your lordship. May look at two documents. 2008 Municipal Corporation's letter, my lord. Annexure 5. Report of the committee formed to scrutinize the claims of the NMR worker of the Cuttack Municipal Corporation regard to allow high skills, chemistry wages. See, there are internal page 28. Running page 28. Narottam Mandi, HS matriculation, HSC certificate, beat microcom certificate, some beat.
The certificate delegan delina apna.
Ochi sa काम करते हैं.
Delina na committee.
Just a moment. This is committee.
मत पचल ले मुझे.
Delina hati केम किधर all you have scrutinized.
Committee pa अपन तक किची.
Look at page 28.
केम दी जानले
आज ही given a rejoinder to this.
I have not received it.
No, how do you say you have been, that those documents are scrutinized? Where is it?
My lord, your lordship may look at page 26 of my report.
26.
Yeah.
The committee went through the draft recommendation of the previous committee formed for the self-same purpose as per orders of the municipal commissioner. Its meeting dated so and so. The committee also scrutinized the documents relating to the date of birth, previous orders regarding rate of wages, certificates pertaining to their qualification, nature of work assigned to them. You have verified everything, sir.
My lord, I am.
So how could you write this?
ମତେ ପଚାରୁଛନ୍ତି ଗୋଟେ ମିନିଟ କହିବାକୁ ଦଉଛନ୍ତି ମତେ ମୁଁ ବର୍ତ୍ତମାନ କାଉଣ୍ଟର ଦଉଛି let him file a rejoinder to it.
Just hold on.
All falsehood here.
My lord, if not giving a rejoinder, it doesn't become a falsehood.
Just a minute.
Petition I am facing.
What is your name?
My Narottam Manti, page 28, top my lord, 12, serial number 12.
Serial number 12.
12. Narottam Manti.
So you have given those documents.
My lord, engagement order, librarian recommendation.
Document produced is there, all the documents.
My lord,
are
I
given,
have
sir.
ଗୋଟେ minute ଟିକେ. I have filed a counter.
I am going beyond counter rejoinder, sir. It is old matter, it should be finished.
My lord,
I should
it should be
waste
finished,
time on
but it
counter
should be
rejoinder.
finished in the way.
Your documents says that he has produced all the documents.
My lord,
Come to that paragraph.
This committee has inquired after that.
Come to 26 now.
Sir.
Come to 26. Come to page 26.
Counter ଟା ଦଉଛି.
HSC certificate given, PIT micron certificate given, engagement order given, library recommendation given. What else you need?
My lord, the committee after that, the inquiry committee found that he didn't produce anything. That is the he may deny it.
Sir, what are you saying? You are saying a contradictory thing. Your report says the report.
Not that report, my lord. After my lord, it was found out that the CMC large number of corruption and fraud occurred. These honorable was at that time also directed to make an inquiry. And after that, it has come. Now he has not denied it.
Inquiry was in respect of why Ramulu, who had passed from
2014 inquiry. After that,
I am coming to 2014, my lord. I am coming.
So you have given fraud certificate.
Yeah.
And he fakes.
He may counter it in a rejoinder.
Even any certificate is false or allegation is fraud is there.
You may counter it in your rejoinder.
In 2000, let me take your lordship to 2014.
So what counter rejoinder is saying?
My lord,
you have filed the counter.
My lord,
he wants to file the rejoinder.
Yes, he should.
It is up to his choice.
No, it's up to. But my
sir, counter is compulsory, rejoinder is optional.
I know.
Then
my lord, I know. But
counter file kale na nahi.
मते तो गोटे मिटी कहयक थे.
वो दोजी.
My lord, counter जदि न देले ताले report से कलेनी. Report जदि कलेनी ताको कथा को. ताले कोन हैला मो कथाटा सत हैला ना नहीं.
तो आपण report कर दे.
Report करंतु.
Report कर दो.
I am making a statement.
ताको कथा
सेमी statement हुए म. Court of record.
Report कर दो. I will pass a proper order. Okay.
My lord.
Okay.
ऐसे report करो.
Land council for the petitioner 1 week time to file the rejoinder. List the matter on 15 July.
My lord.
I will pass a detail order.
My lord. से आपण करंतु सेटा तो मु चाहूँ.
आउ आपण दी जना written submission देबे.
हां.
Next.
What counter टा written submission.
2014 में आपण नौथिले आपण जाईथिला दरकार पड़ना बाबा.
ठीक है
सर. report से recommendation.
That is he's
mu jota that is the way. My lord,
yeah.
They are not privileged. It is the lawyer's privilege.
Not lawyers.
Next.
Item 28.
28.
May I please, your lordship? Well,
Yes.
I am appearing for the petitioner. The
Yes,
counter has not filed yet.
Which year? 2017 counter not filed. 2017 counter not filed. Your father?
Number 1 and 2.
OP number 1 and 2. What are you showing that? You are new council. You are new council here. You are the new council in this matter.
No.
Then your name is there, sir. PK
No.
Khuntia is there.
No.
No, it's there.
Yes,
BP Tripathi.
your name comes.
Khuntia now removes. Okay, the name of Mr. PK Khuntia be removed. And in place of the said names, let the name of what is that? Bibu Prasad Tripathi and associates, okay? List the matter. 8th July.
My lord, on last 3 occasion I appeared, instead of my name, previous council name has been reflected on the order.
तो हटाओ इनका नाम, आपका नाम?
Priyadarshini Amrita Panda.
प्रियदर्शनी अमृता पंडा और छोटा वाला नहीं आउट मझे अमृता टा घुसी गला ओके
Obliged.
Item 29.
29
May I please, my lord?
It's for one passover.
29
Yes.
Madam.
30
30.
30 yes
I'll copy of the rejoinder.
I will serve.
I will serve.
you have filed it
Yes, so I have filed, madam.
the copy of the original be served on the council for the petitioner sorry you have for the opposite party na
Copy number 3 and 5.
copy number 3 and 5 22nd July next 31st
31.
31
Last of kind of a glance.
कौन केस टाइप कौन तो then glance आगो केस को
This is with
Lords, may I, my lords,
Let us-
item 31, Lordship, Mr. Satyajit Misra was supposed to conduct the matter, my lords. Due to medical emergency, he has to go to the hospital, your lordship. Because his father is,
let
let it come next week any day, my lords.
Next week.
you do one thing you other you take the file and read
I'll take the file, my lords, may call it on Monday, my lords.
Monday
My lords.
Not Monday, Wednesday.
okay Wednesday 26th you take the file and
My lords,
because
I-
he might not be able to now read the file
Lordship.
ठीक next
32.
32 Passover 33 33
32, I have found difficulty after launch.
so 32 times so let it come on some other 26 26 as
Madam.
26 as you have some difficulties in Passover next
33, my lord, my lord and senior seeking for Passover, my lord. 33.
okay
My lord and
32
senior
is
seeking for Passover.
no, 32 let's
I'm ready.
what is the matter about
I'm extremely sorry, but I interrupt me. Item 31 may be taken up on Thursday, not Wednesday. Have some person.
Thursday
Thursday or Friday, any day convenient.
27 or 27 good.
Okay.
Next
Here, my lord, last occasion, it was passed over. Here, admittedly, for a shortage of only 1548, 1548 टंगा 6 tickets, I have been disengaged from service. So far the inquiry part is concerned, it has not been dealt with properly, for which I have approached this Hon'Ble Court, wherein order has been passed under Annexure 4, the operating part is at page 27. For that it was quashed and it was remanded back to the authority concerned.
then what happened?
Then, my lord, they have passed this order, which is the impugned order in the writ application. It is at Annexure 7, my lord. Admittedly, I am now at the age of 59. my lord. 1 year or some months left. For this charges of disproportionate on the ground that I have challenged, only for this shortage, I have been disengaged because at that point of time, the conductors on the OSRTC, by way of interview, they are being appointed. So after continuance of for more than 15 years, they have not been regularized, for which they have raised this demand before the authority concerned. While they are in discharging the duty, all of a sudden there was a checking, and in checking and the midst of the way, it is found that out of the total 32 tickets, only 6 tickets it has not been accepted, and the shortage is 1200 some odd.
ରାସ୍ତାରେ ଯୋଉ ପସନ୍ଦ
ରାସ୍ତାରେ ଯୋଉ ହଟା ଯାଇକି ଗୋଟେ checking କରନ୍ତି,
ଟିକେଟ ଦିଆ ହୁଏନି
ticket କାଟିଥିଲା टिकट
टिकट दिया हुआ नहीं ना डुप्लीकेट टिकट दिया हुआ है
नहीं डुप्लीकेट तो नुहे
Yeah,
टिकट कटा नहीं था मो केस रे टिकट कटा
दे
नहीं
काटन देनी पैसा दे दी
ଆଜ୍ଞା।
बस जाते लोग
दैट एक्सपीरियंस ऑल
दिस इज हार्ड
एटा आउची रे एतिके पैसा पाइका मोर गरीब लोग कंडक्टर जे रेगुलराइज भी हेनी फॉर दैट पर्पस आई हैव बीन देयर इज नो अदर एलिगेशंस आई शुड कंसीड फेयरली एंड मो पाखर मध्य बयस सीमा चाकरी सब जाक भी हेले भी जेते मो पार 10 मास ये इट इज ए डिसएंगेजमेंट ऑफ 2017 at annexure by 13
you are left with only 1 year
आज्ञा मु बोधे 10-11 मास अछि 1 year हबो कि नै एवं जो ऑर्डर टा मते देले दैट हैज आल्सो
what is
बीन
wrong in that order
my lord
what is wrong in that this order of this disengagement what are the I mean,
they have not been given any chance so far the hearing is concerned so far the proceeding on that on that score that has been rejected then it has been remanded by kind have a glance to the annexure 7 is the impugned order page 33 for a moment being appointed the discipline authority Keunjhar such and such on the ground that find conductor guilty of the charges case is disposed of with the following rulings ex contractual conductor Sri Ramesh Chandra Chakravarti has to pay MB fine usual
you are in a contractual job
हाँ रेगुलराइज करी नथिले रेगुलराइज
so
पेंट डिमांड
contractual job re jodi apna once you are found even for 1 rupee also shortage there maybe they can take such decision you cannot force the you are not in a regular job regular had it
नहीं we have not been regularized our demand is for
But
regularization
in the
and
contractual
continuance
service,
for a long time
maybe but the contractual
since
service, they
93
not
I was
giving you the
continuing
performance, they might disengage you
but this is not the ground matter disengagement
They
your
can
lordship
give-
know the OSRTC
yeah, OSRTC, but when you are just horrifying people on the road
1290 टका that is the finding my lord only that ground I have been disengaged
1290 ଟଙ୍କା 90 ପଇସା ହେଲେ ବି they can
बेले बेले पुणी 9 कोटी खाइके पुणी खलासी
ହେଲା,
पळेई
that
जाउछन
they can't
ना 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 I am not on negative
that-
equality
that is
I am
the-
not
that
on
is
negative
not-
equality
so
But I leave
in
it to
that
the
case,
mercy of
you
your
should
lordship,
start-
a poor man who is out of employment since 2017. 93 I was appointed. Have served for a quite long period. And apart from that, there is no other
Mr.
allegation.
Jena, you must be there the dealing officer then
He has got the vast experience as assistant law officer
I
in
know,
that OSRTC.
I know. He must be knowing also. He must be busy in the thing also.
That is surprise checking re 1290 ଟଙ୍କାର
OSRTC.
6ଟା ticket.
ହେଇଛି ତ ନେଉଥିଲା ପାସେଞ୍ଜର ନେଉଥିଲା ଡବଲ ଟିକେ ଥର ଆପଣ ଅସୁବିଧା
ସେଥିପାଇଁ ତାକୁ ଚାକିରି
ତାର 8.8 of 64 ଗୋଟେ ସର୍କୁଲାର ଅଛି that circular governs the field ଯେ ନେଲା at the time of before leaving the bus they must issue the ticket to every passenger
ଏ circular ଟା ଦେଖାନ୍ତୁ
yes that is there
That's why I asked Mr. Jena because he knows in and out of
Man.
OSRTC.
that is there
Yes.
8.64 it has been held
And more of a security money be
ସେଇଟା ଦେଖିଲି ଟିକେ ସେ circular ଟା
that
circular କହିଲେ sir
I shall produce that
note କରନ୍ତୁ note କରନ୍ତୁ
ନା ମୁଁ ନେଇଯିବି ମୁଁ ନେଇଯିବି
circular ଟା ଦେଖନ୍ତୁ ମୁଁ ଟିକେ ଦେଖିବାକୁ ଚାହୁଁଛି ହେଲା I am just କେବେ ଲଗେଇବି ଆଉ ସେ
ନାଇଁ
circular
ଆର
ଟା
ସପ୍ତାହକୁ ରଖିଲେ ହବ
ଆପଣ ଲେଖିଦିଅ note କରିଦିଅନ୍ତୁ sir circular ଟା ଟିକେ କୁହନ୍ତୁ
8.8 by 64
8/64 date
8 by 64 ରେ 8/6/64 ବୋଧେ
ମାନେ 1964 ର circular
ହଁ 1964
that is still holding the
yes yes so Odisha High Court be held court it is valid
judgment ଅଛି
yes
judgment ଆପଣ ଟିକେ ଦେଇପାରିବେ ସବୁ ସେ ମିଷ୍ଟର ଜେନାକୁ ପଇସା ତ ଆମେ ନେବୁ ମୁଁ ଆପଣ ସବୁ ଦେବି ଆପଣ ଟିକେ କାଢିକି ଦିଅନ୍ତୁ
ଆଜ୍ଞା ଆଜ୍ଞା ଦେଲ
ଜଜମେଣ୍ଟ
ଆସନ୍ତା ସପ୍ତାହକୁ ଥାଉ
ଠିକ
ମଙ୍ଗଳବାର ବୁଧବାର ଯୋଉଦିନ
27 if there is a standing instruction then I can't protect you.
But still then this court has the ample jurisdiction
Here for the so you should have produced that
he can produce because he is the authority
my humble submission man is a contractual
no fine contractual সেটা our embolden that will embolden your stand
and he has approved this order court earlier
that I have very concern
ଦେଲୁ detail inquiry ହେଲା detail ତାକୁ opportunity of hearing ଦିଆ ହେଲା
ଠିକ ଅଛି ସେ circular ଟା ଦେଖନ୍ତୁ ସେ circular basis ରେ I can pass
ଅଛି ମୋ ପାଖରେ କାଇଁ ବ୍ୟସ୍ତ ହଉଛ ପଇସା ଟିକେ ନବ ନବ କିନ୍ତୁ ମତେ ସିନା କାଟେ ସରି ମୁଁ ଆଉ କହିବିନି
okay
I will produce
you get that next
Sir, 33 টা pass item 33
33 yes এটা 27, Mr. Tripathi. 27.
Your lordship directed that the seal cover is to be brought before my lord's notice.
What is that seal cover? I don't remember.
As per sir. Should I start it or my lord should see the seal cover?
No, best get the recap of what.
Yes, sir. For recapitulating the matter. The petitioner was appointed on the direct recruitee as excise sub-inspector on 2/9/1996. Thereafter, my lord, a disciplinary proceeding was initiated against the petitioner in the year 2012. She was placed under first of all, she was placed under suspension. The reason of suspension was not described. Therefore, he approached the London State Administrative Tribunal to get the to ask the authorities to show why he has been placed under suspension. When the notice was sent, then thereafter a proceeding was initiated against him, and he was communicated of the proceeding before 3 days of the DPC was going to sit for the post of promotion to the post of SI to the inspector. Thereafter, my lord, in that original application, he was given a miscase was filed and order was passed that the pending of the miscase will not stand as a bar for consideration of case of the petitioner for promotion. The DPC considered his case and directed that since the proceeding has been initiated, let be kept under the seal cover. In this process, my lord, the disciplinary proceeding ended with the full acquittal of the allegations made against the petitioner. So he approached.
After how many years that ended?
My lord, 4 to 5 years. It took so that was not because of my latches, because of the latches of the authorities. Thereafter, in the meantime, while it was continuing, promotion to the post of deputy superintendent from the post of excise inspector was there. His case was not considered, though in the gradation list he was shown up as serial number 5. Persons those are below him in the gradation list, they are considered and they are given promotion. At this juncture, your lordship, when the matter was heard, your lordship came into that Janaki-Raman's case by following it. If the seal cover will be disclosed that the allegations made against him was because of the pendency of the disciplinary proceeding, and disciplinary proceeding since ended with acquittal, then he is entitled to the promotion with effect on the juniors are promoted. That is why your lordship wanted to know what is the finding or what is the decision of the DPC relating to the petitioner.
Departmental proceeding record and
no, seal cover proceeding we are not interested. That
se joda bahar ku rakhi se seal cover. Atar se seal cover proceeding ta seta mo page flag marking korichi.
Sir, file. Was it a seal cover or open cover?
No, seal
cover.
Yes, cover.
No, flag mark seal
No, flag mark ta proceeding ta korichi.
Okay.
For the convenience of the courts.
In India, there should be some law passed by the either Supreme Court, Parliament somewhere. The seal cover business should go. This is very bad.
Sir, setup should have been, but in this instant case, seal cover has been adopted, and Hon'Ble Apex Court has also said that in Janaki for and the
in many cases, Apex Court
they have said
the seal cover business also.
Initially, they said that now they said you should not open you should not have followed the seal cover. However, it is followed here. We are interested of the petitioner. There, Jyotirmay Patel Delegi, sir. We are concerned about the petitioner.
Jyotirmay Patel. The recommendation of the Departmental Promotion Committee held on 14/3/2013. Disciplinary proceedings pending.
Sir. There are 3 seal covers. That is why there is a confusion.
One of the seal cover is suitable.
Exactly.
Suitable for the promotion to the rank of Inspector of Excise. His seniority will be placed below Sitakanta Muduli, SI of Excise, and above Sikh Asaf Ali, SI of Excise.
They have been promoted to the inspector, thereafter the deputy superintendent of excise.
So then why should this person not consider that? Hmm?
Your lordship may dispose.
Okay.
I am giving two judgments for my lords. One is Justice Syed Sagir Ahmad and another is Justice Aven Misra.
Okay.
As CJ at that time. No, he was not a CJ then. Following the same principle, they have decided. Obliged, my lord.
Photocopy.
I will provide the photocopy, madam.
Next. Next.
Item number.
I may be pardoned 1 minute, my lord. I'm sorry that I'm disturbing my lord's proceeding. Item number 40. 40. There is a noting that they have filed a counter, they have not served me a copy of the counter. If my lord should direct, they will serve a copy of the counter.
Okay.
So that
Serve a copy
yes.
in 40.
40, that was served a copy.
Serve a copy.
And I may be given 10 days time to give a reply.
You're for the petitioner.
I'm for the petition.
10 days time. 19 July. 19 July, sir. Next.
Item number 34.
My lord.
34.
That doctors are available, but the head of department is not available. As so far my inquiry is concerned, your lordship may direct to Command Hospital, Eastern Command, Alipur Road, Calcutta. It is
That
best.
matter.
That matter.
So then you do it from Alipur, Kolkata. So in 34, na?
34.
So now the hospital proper
Like
nada
the-
did
Take it.
little like this. Within a week? Within 2 weeks? Within 2 weeks, kepe jibi na Calcutta visit I'm fixing a date for. Kepe date the
3 weeks.
10 July. I'm fixing a date for 10 or 11 July. 2 din de do, so that confusion avoid. 10 July, 10 or 11 July. Present himself before the medical board constituted by the. Who is the head of that hospital?
Register Command Hospital, Eastern Region. Register Command Hospital, Eastern Command.
Eastern Command.
Eastern Command. Register. No.
What lekhi did
Monday.
it? So there should not be any confusion. Hala. I'll list the matter on August. 2nd August. Next.
35.
35.
My lord, on behalf of Mr. Dasan, pass over, my lord. Pass over.
Pass over. Yes. 36.
36.
36. You are in 35.
35, man, I am 35.
So
I am 30.
he asked for passover. So you want to answer?
I am here. Okay.
Okay, you start.
This was heard by my lord.
I don't remember. Just can you recap?
Yes, I will recapitulate without opening the brief also I can. My lord, what happened, my lord? 40 posts under the UR category for the post of DSP was required to be filled up.
I remember, yes.
Yes.
That,
39, the calculation only, my lord, the mathematics. What they have done, they initially fill up 39%. By 39%, we are in the list of the DPC. Our position was 42 to 47. What they have done, subsequently, 2 other person was given promoted. That means the promotion comes to 41, beyond 40. Another person whose case was in a shield cover, he was also given a promotion from the same advertisement, same year. So it come down
but
to
you are saying
42.
something else.
He was saying that one ST, my friend was not there, another learned
Mr.
counsel was-
Patnaik, Mr. Mohanty was
Mohanty
there
was
on the
there,
last
yes.
occasion. My lords, our stand is that one out of those 40, one post was an ST candidate, my lords. So therefore, the final comes down to 38. And the rest, 39 and 40, which were to be filled, those were filled from the 7 waitlisted candidates according to the 1.25% rule, your lordship. Because those 8 candidates, they were there selected only in the list in case there is any unforeseen vacancy, my lords. Now the stand of the petitioner that because 7 DSPs have already been promoted, now that doesn't make it an unforeseen vacancy, lordship, because that will naturally come up in the next list, which is drawn in the next year, 2015, my lord. So this is our whole stand, your lordship.
Let me
Lord,
clarify.
I'll prepare a note,
Dates.
but may I only
Both of you prepare a note.
with
I
permission of my
I prepared a small note and my affidavit. Kindly have a glance to that.
I've just seen, I've already heard it 2-3 times.
Yes. Yes. Now what they are saying, I have now given an additional affidavit on the other day. I have given it, just I want to show that Mr. Topo, who was shown to be ST, he continues to be against the UR vacancy, not against the ST vacancy. That was not a fact. Kindly see 2 documents. But the DPC proceeding 2012-14 is at annexure 1. And the proceeding, kindly have a glance, my lord. The page 22.
Which writ petition? The first one?
Yes,
35?
first one, first. So good a carbon copy. There is no distinction. Page 21.
21.
Yes, this is the DPC proceeding 2012-2014. Now, my lord, page 22. The categorized vacancy. You are, my lord, top the tabular form. You are 61.25%. That is why they have calculated the last about 1 column to be filled up 40. These are the your vacancies.
Give a note with all this.
Yes, I will give it. Just refresh kar choti puru to apno pura bujh jaytile mate just.
I know that. I understood this.
So now just out the line koi do kindly. This is the 40. This Topo continues in the same list. He was never promoted against the ST vacancy. He is a ST, but there is no bar on the statute that the ST can also be considered against the UR vacancy, and that is the fact for which he has been promoted. He has been promoted to the post of DSP, and now he has also been further promoted to the post of additional SP. That document also I have given.
The Topo.
Yes, that Topo, who is a ST. Even considering for argument's sake, my lord, yes, Topo is a ST. Then if the vacancy is 40, now if it will come down to 39 means it will come down to 38 plus 2. That Prakash and Subhas, there's lateral entries, their number come to 40. Now on Lalit Patnaik, again promoted from the same year selection. So it will come down to 41. How it would be? If the vacancy is 40, how it would be 41? That is the point. How it became, that is why we have approached the promotion adalat. And learn promotion adalat.
Promotion adalat say?
Promotion adalat says he give this because these some 7 additional DSPs were given promotion in the same year to the post of additional SP of the same year on 16/9/2014. Our DPC was on 2012-2014 December. So these 7 vacancies were directed to be filled out. Promotion Adal says against because you have given it to some other person, 1 post. So balance 7 out of 7 other posts had to be given to the other person, those who are in the merit position in the DPC. That is why, my lord, we the 5 person are to be accommodated against these vacancies. This is the crux, my lord. I will give it.
Both of you.
I'll file my notes, my lord.
So give it by 26th.
Mine.
So I'm fixing 26th again for the note.
My lord.
Otherwise, note, nothing produces. When I start writing, I don't have note. Okay, 2 minutes break. 2 minutes.
Mention କରିଦେଲେ item 40 ବୋଲି କହିବି
40.
ସେ
40
Mr.
is.
Yes,
Oh,
my lord.
say
that's
the
there.
40 is Bini Misra.
ହଁ ସେ ସେଇଟା mention କରିଦେଲେ
That's why I was thinking. 40 is your matter, na? Mr. Ratha is wrongly mentioned your item and he left it. That is 36, I think.
36
Okay. 36, 36, I said 36, 36 I call it.
नहीं
The 40 is able to 36 करते हैं ना? 37.
37
Lord. Sole question is, Lord, the persons are selected prior to 1/1/2005 and appointed after 1/1/2005.
What is the person? What is the post? Please give some
Yes, sir.
light.
Your lordship, annexure A by.
For
annexure-
अभ्यास छाड़ନ୍ତୁ ये फटक से आसिक एनेक्सर को डाकिवा दैट इज अ वेरी रॉन्ग एडवोकेट
Selection.
नो नो सॉरी
Selection.
आपण फैक्ट्स ये कहबे तापर एनेक्सर डाके एडी ई सिस्टम को जदी जा कम टू एनेक्सर 1 एनेक्सर 2 जदी सब से जानि थिबो मु 60 फाइल पढी के आस्तुबी आई डोंट हैव आई कैन रिमेंबर एवरीथिंग आपण फैक्ट्स आटी इंट्रोड्यूस करिए तापर एनेक्सर गले से ना
Lord, we were.
इट इज एनली इट इज आपण जूनियर प्लान सिखिबे सेते मैं डेली कहूची
Lord, we were
nobody
selected-
should come to the annexer first. Everybody should introduce the topic, introduce the issue, then go to the annexer. That is the first thing you should do. Now start from the your issue.
Lord, we were appointed
Yes.
as we were selected as LFS cadre,
What is LFS?
local fund service
Local fund service. Okay.
cadre, and the selection was made in way back in 2000.
2000?
2000.
2000. Okay. What happened?
Though they have not given us the appointment, but various litigations were started. They have started.
You are the selected candidate.
Yes, sir.
You have been selected.
Yes, sir.
Then why they have not given you the job?
They have not, subsequently, they have abandoned that we will not give the appointment from that list. Then subsequently, this honorable.
Why?
court-
Is there any specific reason for it?
There no specific reason they have indicated. They have said that at present we are not taking any decision to give them appointment. However.
So your question is, you conducted the interview, you and we were found to be eligible and selected,
Panel was prepared.
and
but no
finally they
appointment was
abandoned.
given. No
Finally
appointment-
they abandoned the list.
no
Yes, sir.
appointment was given, my lord.
So
In 2011.
Aja मोटे कुत्ते कथा कहନ୍ତୁ. Can a person, as a matter of right, say कि okay, because you have selected, you are bound to give me job? Can he say like
My lord, divergent views are there.
No.
Once, my lord, let your lordship put
No,
a
no,
question,
think-
let me to give the
Okay,
answer.
you answer.
First point,
Hmm.
even if a person is empaneled and enlisted in the panel, he has
Sir,
no right to get the
Sir,
appointment.
just panel is a different thing. Here is a fresh advertisement, open advertisement from the market, right?
Here, my lord,
Huh?
here, my lord, they called for the names from the employment
Exchange.
Yes.
That's
Then
open.
selection board.
That means open and open
Yes,
market.
yes.
Open market.
Then selection board was constituted under Rule 7.
Hmm.
Then selection board finalized 175%, and they have not
Give
given.
me one judgment which says, once you are selected, you are bound to give me
Not-
job.
If your lordship
Is there
will-
any
If your
judgment?
lordship will allow me, but I'll clarify.
Okay.
From 2011, they have started, after interference of this honorable court, they have given the appointment to the person.
Appointment ଦେଇଦେଲେ?
Appointment ସେମାନେ ଦବା ଆରମ୍ଭ କଲେ.
ଆପଣ ବୁଝିଲେ ଦେଲେନି ଦେଇନି ବୋଲି
ସାର୍
ଆଉ starting ରୁ ସେଇଆ କହିଲେ ମତେ
ସାର୍ ସେମାନେ ଦେଲେନି ବୋଲି ଆମେ କୋର୍ଟ କୁ ଆସିଲୁ
ତାପରେ ପାଇଲେ ଆପଣ
ତାପରେ ଆପଏଣ୍ଟମେଣ୍ଟ
after
2013 ଫେର ବନ୍ଦ କରିଦେଲେ କହିଲେ ଆମେ ଆଉ ଏବେ ଦବୁନି ଏଗେନ୍ ଦିସ୍ ଅନରେବଲ
ବଟ
କୋର୍ଟ
ଯାହାକୁ ଦେଇଦେଲେ ତ ସେ କଣ୍ଟିନ୍ୟୁ କଲା ନା
ସେମାନେ କଣ୍ଟିନ୍ୟୁ କଲେ
ଆଉ ତ ଆପଣ ସେ ନଦେଲା ଭିତରେ ରହିଗଲେ ପୁଣି
ହଁ again this honorable court has directed that you cannot in that case I am referring blood that judgment I have given that is available
ଜଜମେଣ୍ଟ ପରେ ଯିବା ଆମେ ତାପରେ ଫ୍ୟାକ୍ସ ଆପଣ ମୂଳରୁ ଭୁଲ ସେଇଟା କରୁଛନ୍ତି ଆଉ
in 2016 11 to 2016 we were given the appointment against the contractual post. Subsequently, again we approached this honorable court. In 2019, this honorable court directed you cannot give them a contractual appointment because other persons from the same panel you have given already regular appointment.
Okay.
Therefore, their service will be taken as a regular with effect from 11 to 2016.
Okay.
Then we made the representation. Since our selection was made prior to 1/1/2005 and you have given us appointment after 1/1/2005, therefore we will be governed under the pension rules 1990.
Now
That is our case.
now your grievance is the pension rule.
Exactly.
ଏତେ କଥା କହୁଛନ୍ତି ସିଧା ପଏଣ୍ଟ କୁ ପେନସନ
ସେଇଥିପାଇଁ ସାର୍ କହୁଥିଲି ଯେ issue is one
ପେନସନ ଇସୁ ଇଜ ପେନସନ ତାପରେ ବ୍ୟାକ୍ ଟୁ ଯିବେ ସେଥିପାଇଁ ମୁଁ ପଚାରେ ହ୍ୱାଟ ଇଜ ଦ ମେନ୍ ଇସୁ
This is only my limited grievance that since you have been selected.
Now can you give me a judgment where you say just because you have been selected in suppose 2001 or 2 or 3 before 2005 but your job has been given to you
After
in 2011 or 12 or whatever or 2008
Right.
so will you be governed by the old pension rule or new pension rule
Pension rule.
କୋଉ pension rule
Old pension rule 1990.
କଣ ଅଛି ସେଥିରେ ଆପଣଙ୍କର ଯୋଉଟା ଗଭର୍ଣ୍ଣ ହେବେ ସେ ଲାଇନ ଟା ଟିକେ ପଢନ୍ତୁ
ସାର୍ ଏଇଟା ଖାଲି ଡିସିସନ ଟା ଆପଣ କହିଲେ ମୁଁ ସେଟା
ଡିସିସନ ରୁଲ ଟା ପଢନ୍ତୁ କଣ
ହଁ ସାର୍ ମୁଁ କହୁଛି
ଡିସିସନ ଟା
ଏଇ ଏକ୍ସାକ୍ଟ ସେଇ
ସୁପ୍ରିମ କୋର୍ଟ ଦୟାକରି ସୁପ୍ରିମ କୋର୍ଟ ଦିଅନ୍ତୁ
ନାଇଁ ସାର୍
ଏଟା ପୁଣି ଯିବ ସୁପ୍ରିମ କୋର୍ଟ ନା
କନଫର୍ମ ବାଇ ଦ ସୁପ୍ରିମ କୋର୍ଟ
କନଫର୍ମ ମାନେ କଣ ଡିଲେରେ ବି କନଫର୍ମ ହଉଛି ସେଟା ପୁରା ଜଜମେଣ୍ଟ ଲେଖିକିରି କନଫର୍ମ କରିଛି ନା ଏମିତି ଡିଲେ ଗ୍ରାଉଣ୍ଡ ରେ ଡିସମିସ ହେଇକି କନଫର୍ମ
ନାଇଁ ଡିଲେରେ ନୁହେଁ
ତ ଫିର
ଡିଲେରେ ନୁହେଁ
ପୁରା ଜଜମେଣ୍ଟ ହେଇକିରି ପୁରା ସେ ଜଜମେଣ୍ଟ ଟା ଦେଖନ୍ତୁ ତାହେଲେ
ଦେଇଛି ସେଇଥିରେ ସାର୍ ଲକ୍ଷ୍ମୀ ଯଦି ଫାଷ୍ଟ ଜଜମେଣ୍ଟ ର
ସାର୍ ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ ଦଉନାହାନ୍ତି ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ ଦିଅନ୍ତୁ ଓଡ଼ିଶା ହାଇକୋର୍ଟ ଜଜମେଣ୍ଟ ଠିକ ଅଛି ବଟ ସୁପ୍ରିମ କୋର୍ଟ ବି ଦିଅନ୍ତୁ
ଏଇଥିରେ ମୁଁ ଗୋଟେ ଲାଇନ ସାର୍ ପଢିଦେବି ଟିକେ ଗୋଟେ ଲାଇନ
ନାଇଁ ମତେ ଜଜମେଣ୍ଟ ସୁପ୍ରିମ କୋର୍ଟ ଦରକାର
ସାର୍ ମୁଁ ସେଇଟା କହୁଛି
ମତେ ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ ଦରକାର
ଏଥିରେ ସାର୍ ଗୋଟିଏ ଲାଇନ ସାର୍ ଖାଲି ମତେ ଟିକେ ପଢିବାକୁ
ହଁ ପଢନ୍ତୁ
ଏଥିରେ ଲେଖିଲେ the judgment of Anand Das, I have given that decision.
I don't know that Anand Das
Was challenged before Apex Court in SLP number 35462 of such and such 2014. And the Apex Court upheld the judgment of this court by holding that since the appointment against the vacancies of the year 2003 was made prior to amendment of 2005 amendment rules 2005.
just hold on sir ସେ କଣ ଲାଗିଲା ସେ ସେଣ୍ଟେନ୍ସ ଆଉଥରେ ପଢନ୍ତୁ
The judgment of Anand Das was challenged before the Apex Court in SLP number civil number such and such of 2014, and the Apex Court held that Apex Court upheld the judgment of this court by holding that since appointment against the vacancies of the year 2003 was made prior to amendment of 2005.
Appointment
since appointment that selection was made the case hochi
ଆପଣ appointment ବୋଲି ପଢିଲେବେ
ନା ଏଥିରେ ଲେଖା ହେଇଛି କିନ୍ତୁ କେସ୍ ହୋଉଛି ଏଥିରେ ଆଗ
ଆପଣ appointment ପଢିଲେ ଆଉ ଲେଖା ହେଇଛି selection ବୋଲି
ମୁଁ ଯାହା ଲେଖା ହେଇଛି ମୁଁ ସେଟା ପଢିଲି ଏଥିରେ କେସ୍ ହୋଉଛି 2000 ମସିହାରେ ସିଲେକ୍ସନ
ମୋର proposition ହେଲା can a person who was selected prior to 2005 prior to the beginning of the new pension rule who was later appointed after the cut-off date can he be considered prior or post that is the question
नहीं सर मु दीटा डिवीजन बेंच ऑफ डिसीजन
डिवीजन मैंने सुप्रीम कोर्ट दियो सुप्रीम कोर्ट हला बहुत इजी my hands will be broadened आपन फेवर दियंतु ମାନେ କୋଉନି ଆପଣ against
ନା ନା ମୁଁ ସାର୍ ସେ କଥା ମୁଁ ମୋ କହିବା କଥା ଯେ ମୁଁ ସୁପ୍ରିମ କୋର୍ଟ ମୁଁ ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ ପାଇଲିନି କାହିଁକି
ହଁ ଦେଖିଲେ ପାଇଲେନି ଆପଣ
ନା
ପାଆନ୍ତୁ ତାହେଲେ
ଏଇଟା ଓଡିଶା OCS ରୁ
ସାର୍ ଏଥିପାଇଁ କହୁଛି ମୁଁ ଏଭ୍ରି ଟାଇମ୍ ମାଇ ଫୋକସ୍ ଇଜ ଅନ୍ ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ କାହିଁକି ନା ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ ଥରେ ଆପଣ ପାଇଲେ ଆପଣ ପୁରା ଏମ୍ବୋଲ୍ଡେନ୍ ସୁପ୍ରିମ କୋର୍ଟ ଯିବା ବି କେସ୍ ଆଉ କିଛି ହେବାର ନାହିଁ ସୁପ୍ରିମ କୋର୍ଟ ରିଲାଏ କରି କରାଯାଇଛି ନା ସୁପ୍ରିମ କୋର୍ଟ କନଫର୍ମ କରିଦେବ ଆମ ଜଜମେଣ୍ଟ ଦେଖିକି କରିଛ ଚାଲ ହେଇଗଲା
ନାଇଁ ଏଇଟା ତ
ଆଉ ଏମିତି ରିଭିଜନ ବେଞ୍ଚ ଦେଇକି ଯିବେ ସେଠି
ନାଇଁ ନାଇଁ ସେଠି
ମାଡ଼
SLP
ଖାଇବ
କନଫର୍ମ ହେଇଯାଏ
ଆଜ୍ଞା ସେ SLP ର ମାନେ କଣ କହିଲେ SLP ର ଗୋଟେ ଲାଇନ ଯୋଉ ଜଜମେଣ୍ଟ ଅଛି କି ଜଜମେଣ୍ଟ ହେଇଥିଲା ଏଟା କୁହାଯାଏ SLP ର କିଛି ଇଏ ନାହିଁ
ତାହେଲେ ଆଉ ଗୋଟେ
ଟିକେ ଜଜମେଣ୍ଟ ଦେଖନ୍ତୁ ମିଳିଯିବ ଦେଖନ୍ତୁ ପକ୍କା ପାଇବେ କୌଣସି ନା କୌଣସି ଷ୍ଟେଟରେ ଥିବ ସାର୍ ସୁପ୍ରିମକୋର୍ଟ ଆସିଛି ନା ବିଭିନ୍ନ ଷ୍ଟେଟରୁ ଆସିଛି ଆଉ ଏଇ ରୁଲ ତ ସବୁ ଷ୍ଟେଟରେ ଏଟା ଅଛି ଏଇ ପେନସନ ରୁଲ କହୁଛି ସବୁ ଷ୍ଟେଟରେ ଏଟା ଅଛି ତ ଟିକେ ଦେଖନ୍ତୁ
ଆଜ୍ଞା
ନ ପାଇବେ ଯଦି ଦେଖିବା ବଟ୍ ଆଇ ଅଲୱେଜ ପ୍ରିଫର ଦି ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ ମାଇ ଫର୍ଷ୍ଟ ପ୍ରାୟୋରିଟି ସୁପ୍ରିମ କୋର୍ଟ ଫେରେଇ ଦେଇଛ ସେତେବେଳେ ଦେବେ ଆଉ
Lordship is keeping it to which date, my lord?
I'm keeping it to short date दे दो 28 कर दो
My lord.
28 सुप्रीम कोर्ट आउ को दु तीन हाई कोर्ट अलग अलग जगह भी पाइबे भी जानथांतु टिके रिसर्च करबे ना जूनियर मान को कमे रखि छथि करन ना रिसर्च करले से सिखिबे आ आपण खाली निजे निजे कले के दियो जस्ट यूज देम नेक्स्ट
Item 38.
38
On behalf of Mr. Naik, kindly pass over, my lord.
पास हो ओ पास हो
Item 39.
39
39 on behalf of Mr. Ambika Prasad Rai, kindly check receipt.
चेक रिसीप्ट कोन मु जानिनी चेक रिसीप्ट कहि देले ते लाइन रे मु कोन हबो
Pass over. Another
ऑन बिहाफ ऑफ अंबिका प्रसाद रा चेक रिसीप्ट अब कार्ड चेक रिसीप्ट की चेक रिसीप्ट मुके जाना नहीं
कल pass over.
पास हो
Item 40.
yes 40
May please, Your Lordship. Your Lordship, herein the present petitioner has challenged the selection of opposite party number 6 as the secretary of the trade union, Your Lordship. Secretary of
trade union
NESCO Power Employees Union, Balesur, Your Lordship.
who are you
Your Lordship, I am the secretary that has been selected by the due process of law, Your Lordship. And
selected or elected
I was not selected or elected, I was nominated, Your Lordship, because I was nominated after the death of the previous secretary. And my tenure was supposed to continue for a year, Your Lordship, by the way of resolution.
so
Your
before the completion of the
Before-
tenure
yes, Your
somebody else become.
Yes, Your Lordship. So, Your Lordship, on the last occasion,
So, opposite party number 6 was selected
yes, Your Lordship.
as the general secretary of the NESCO Power Employees Union
Yes, Your
with effect from 3/1/2023.
Yes, Your Lordship.
So what is the ground for your
Your
challenge?
Lordship, the ground is, first of all, they have their selection itself is invalid because the bylaws itself says that before anything, even if they propose to take me out of my place, they are supposed to follow the principles of natural justice and they have to show wherein I have acted in the acted in any manner. Yes, Your
Detrimental to
Lordship.
the interest of the
Yes, Your Lordship.
union.
That has never been done. Moreover, the members were even not notified that a meeting supposedly was about to take place. We directly got to know from the newspapers itself.
Why, sir, so
On-
much
on, before-
hurry in this lodging? The
May
post?
before adverting to the answer, you Lordship make a cost title.
क्या हुआ कष्ट
The application relation relevant provision of the Trade Union Act. Then roster appointment, it is a division's matter. That's why division bench.
Your
matter.
Lordship,
That's why, yes, that's why just.
ना ना division
Your Lordship, this was
क्या matter daily सुनी
No, no, trade union.
Not Your Lordship.
trade union तो
No, Lordship may.
wording आशी तो trade union
I have only mentioned
I'm not
relevant
disputing.
provisions. Again,
हाँ trade
Your
union
Lordship,
election matter आशी हम
this matter had also been placed before the Chief Justice, Your Lordship.
no trade union election matter तो हमारा ची
No, that's on the trade union
you
matter.
don't like me that's a different thing
Election of
If you don't like me, that's a different thing.
No, I'm not on that.
I'm hearing it.
I'm not on that. But once it is the matter relating to trade union act, that's why I just brought to notice that I'm.
Sir, trade union act, I'm a roster achi.
Association.
I've decided many.
An election matter of association.
हाँ,
That's
this-
association.
Association.
It's a trade union, association.
No.
Nesco Power.
The
Clergy
association
Union is
relates
an
to the
association.
Society Registration Act.
No, Your Lordship.
A union ta?
In the trade union, only trade union act.
Trade union.
Yes.
देख लो check कर. Maybe I may be wrong.
Yeah, he has mentioned the trade union act, the provision related.
Yes, sir, relevant provisions.
ठीक है देखी देवा.
Again.
The employees union.
The employees union भी तो हेला ना. Union भी तो trade union रे आसी बनी. Employees union trade union रे आसी बनी.
And registration under which act? That is the question. Register
सेटा हमारे जो देइछथि रोस्टर वाला बने ना थी मुको
Trade union.
registration under trade union act.
Your Lordship,
Sir, employees union, some of the union are under the society registration act. There are two.
society union both आसी.
No. Ask them.
Only association.
Association act.
Okay, let the matter be placed before the.
Your Lordship, if I may mention the background of this case, Your Lordship, this
Out of
matter was placed before a.
Ousted.
No, Your Lordship, this matter was placed before a coordinate bench. The coordinate bench had sent it to the Chief Justice and thereafter it has come, Your Lordship.
देख ले से note टा देख लो.
Justice,
I don't want to just unnecessary pass order and
Your
again.
Lordship, my only predicament is the opposite parties chose not to appear for continuously 4 times, Your Lordship.
Well,
And
I-
thereafter they come up with this plea.
देख लो code लिखा है जी.
Initially it was listed before Justice K.R. Mahapatra. तापर एठी गेस्ट हम कोर्ट लिस्ट है but
But Chief Justice.
Chief Justice
understand
is
it.
roster and understood.
That's not the- Let the matter be placed before the Chief Justice and the appropriate bench. This matter. कौन से दिन लिखा है बस.
Obliged.
ठीक है. You go somewhere else. Okay, next.
Item 41.
Item 41.
ବର୍ତ୍ତମାନ ସୁଦ୍ଧା କାଉଣ୍ଟର ବି ଦେଲାନି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଫ ଇଣ୍ଡିଆ ଆଣ୍ଡ ଗଭର୍ଣ୍ଣମେଣ୍ଟ
ଏଟା matter
ପଲ୍ୟୁସନ କଣ୍ଟ୍ରୋଲ ଆମର
ଏଇ ଯୋଉ ଛତ୍ରପୁର.
ଛତ୍ରପୁର
We have filed, 6 and 7 are filed in the first
ଫାଇଲ କରିଦେଇଛନ୍ତି
state government. and-
ପଲ୍ୟୁସନ
सर केंद्र सरकार एत ढिला काहे होचन केंद्र सरकार तो बड़ा स्मार्ट हो
ପଲ୍ୟୁସନ
ढिला होचन हाई
ଫାଇଲ
कोर्ट में
କରିଦେଇଛନ୍ତି
हां
Major.
एतबे ढिला ही जी केंद्र सरकार तो अधिक स्मार्ट होगा कथा
ସେ ଏବେ
यू हैव ए स्मार्ट प्राइम मिनिस्टर
ହେଇଯାଇଛି
ଆଉ ଉକିଲ ମାନେ दैट शुड परकुलेट डाउन ना
Instruction मागी दीजिए.
I will take a further instruction, my lord.
It
If I
is
have
okay.
a file
You are
counter-
taking time and again.
No, my lord, that file, if I have file counter or not, it's needs regard.
This matter 2023 just file a reply you can finish it just
तो फाइल करिए.
write letter to them otherwise I'll
My lord, just have sent.
They have communicated.
That case is not maintainable. That.
ସେଇଟା ଠିକ ଅଛି ଗୋଟେ ଦିଅ ଲେଖିବ
So in this.
not maintainable
କହିବା କଥା
maintainable
ଗ୍ରୀନ ଟ୍ରିବ୍ୟୁନାଲ ରେ ମେଣ୍ଟେନେବୁଲ ଏଠି ମେଣ୍ଟେନେବୁଲ
Regarding after further.
କାହିଁକି ଏଠି maintainable ହବନି ହାଇକୋର୍ଟ 226 କାହିଁ maintainable ହବନି
ଏଟା ଯାଇନି ଗ୍ରୀନ ଟ୍ରିବ୍ୟୁନାଲ
Form ଅଛି, my lord. If his form is available, my lord directed to there.
why somebody will go to Calcutta Delhi somewhere if it can be heard here
Similar type of case, unforced tribunal, my lord, that's Calcutta, that sent to this case.
ନା ନାଇଁ ସେଟା ଆସିଲା ପରେ ଏଠି ଯାଇଛି ଏଠି ଏଠି ବି ହଜୁର ଡିସାଇଡ କରିଛନ୍ତି ଯେ ଏଟା ଆମର ଅପିଲ ଯେହେତୁ ଅଛି
I have taken any instruction by.
you take instruction you file your reply na and then we'll see
State and union.
state and union.
State-
I have
state also.
received the PWC matter. I will file within 1 week, madam.
State and both of them filed that's the matter କେବେ ଲଗେଇବି 10th July ଏବେ ତ ମନ୍ତ୍ରୀ ଆସିଗଲେ ସାହେବ ମନ୍ତ୍ରୀ ବି ରହିଲେ କଣ ଅସୁବିଧା
42.
We received the counter affidavits, my lord, from the opposite party. My lord. We filed the rejoinder, my lord. 1 week, 1 week time.
Sorry. My lords, I am for OP3 and you are for?
Petitioner.
No, my lords, this is not the stage to say that I'll be filing the rejoinder. Because last time.
Sir, 2024 matter, what is
No,
the
no,
stage?
no, I'm not saying that.
It's not old matter.
No, what I'm saying is, last time, Malards may kindly have the order last time.
ଏଥିପାଇଁ ଗୋଟେ କାହିଁ ଝଗଡା ସାର୍ ଫାଇଲ କରୁଛ ଟାଇମ ଫାଇଲ କରିବ ଏତେ କଥା ହେଲା ଏତେ ଆପଣଙ୍କର ସେ ତଳ କୋର୍ଟର ଲୟର ମାନଙ୍କ ଭଳିଆ କହୁଛନ୍ତି
My difficulty is.
you don't have any difficulties when he is asking for time I should grant you time.
Sir, please listen to my difficulty is I have come physically, let's say from Delhi. So this is my relative's case. So my submission is that the pleadings are last time.
Sir, you appear in this thing.
No,
through this.
Sometimes there is difficulty because this time
we have in our High Court we have facilities. People are appearing from London.
Last time I appeared through VC only, but they could have asked for this. This is they could have asked for this.
I'm allowing because it's a matter of 2024. That's why I'm allowing.
No, that is true, but it was the Honorable Court said it would be the last opportunity, and any party please have the last order, my lords, of this Honorable Court.
Okay.
What may kindly have?
Let me see that.
Please.
खोलने को भी
Of 2nd of May 2024.
अरे खोलने को मैंने
And my lord, they could have asked for and they could have filed the rejoinder.
Yes, just hold on. You are for the petitioner.
Petition.
We have last time also we have taken time 11th March.
My lord,
taken time just a minute, sir, just a minute. Petitioner prays for an adjournment 2 weeks. 5,000 rupees cost.
No, my lord. Your lordship kindly see the counter.
No.
A document they have relied upon a computer.
What is this? Every time you have taken time.
They have relied upon a document, my lord. They have not annexed.
Whatever maybe they have relied, but that you can answer to that. What is this? Every time you have taken time.
They annexed a document, my lord. They have not supplied the copy.
Also, I remember I have just given an order to give 10 copies of D.D. Basu commentary on the Constitution of India book to the Library of Odisha High Court Bar Association. You have given?
Yes.
Copy given? You have given, sir?
Last date mo deho bolna thala mas.
Amrats, what I submit is, Amrats, may I submit one thing?
Again?
Your name is?
R.K. Mohanto, my lord.
Huh?
R.K. Mohanto.
Divedi lekha hai.
First Divedi na tho, second Mohanto.
So kahin dehi na tumhe you have not given the D.D. Basu book to the library as a cost last time I have imposed. I have imposed cost of 10 volume of D.D. Basu should be given to library. You have not given.
No, Jani.
How can you Jani?
My learned friend has not even gone through the order of this Honorable Court.
Para 4. Para 4, sir. Read para 4.
No, Doctor.
He doesn't have the order. Taking the court so casually and coming leisurely.
Not
that date would be given.
I'm again adding some cost to you.
I'm sorry, my lord. I'm sorry, my lord. I will comply. I will comply with you.
Let him argue.
Madam, may I submit one thing? Please. Only, I may kindly be heard and they can be heard on the next. It is a short issue, my lord.
Again and again you are taking time.
The short issue involved is.
Let me place my lord.
It is.
Okay, let him argue.
Please.
Yes.
My lord, present petitioners, my lord, the plus one legal heirs of the deceased, my lord, deceased wife.
Plus one legal heir, how are you related?
My lord, sole question involved in this matter is, my lord.
How are you related? I'm saying.
My lord, petitioner number 1 is the husband, my lord, and petitioner number 2 is the daughter, my lord.
Petitioner 2 is the daughter.
My lord, during lifetime, the deceased made an insurance policy, my lord. In that policy, my lord, petitioner number.
This is the husband. This is the husband.
Petitioner number 1 is the husband. Petitioner number 2 is the daughter, my lord.
Of the deceased policy holder. Of the deceased.
Who is the deceased?
Policy holder.
Wife.
This is how are you related to the petitioner? I'm asking, sir.
Petitioner 1 or wife, say.
Wife of the petitioner 1.
My lord. My lord. During her lifetime, she made an insurance policy, my lord. In that policy, in the nominee column, my lord, she mentioned the name of the opposite party number 3 as nominee, my lord.
Who is opposite party number 3?
Mother of the deceased, my lord. My lord, now, my lord, after her death, my lord, whether petitioners are entitled to that some insured or the nominee, my lord. That
Yeah,
is,
you are appearing for
I am for OP3, the main of
mother,
affected party, the nominee, the mother.
mother.
Please, my lords.
And the petitioner are the wife?
No, husband.
husband and daughter.
Husband
And
daughter.
minor daughter of the deceased policy holder.
husband and minor daughter.
My lord.
So wife was, she's working lady.
Yes, she was working.
Working
She
in a
was
private farm and died due to cancer, my lord.
So what is the total amount of the?
50 lakhs sum assured.
50 lakh. 50.
My lord.
50.
My lord.
Okay, so then what is the problem?
My lord, now the opposite party number 3 claiming that amount, my lord.
So what is the problem in this? Is a very simple case. All are class 1 legal heir. Opposite party number 3.
No, my lord.
Why?
Petitioner number 1 and 2 are the class 1 legal heirs.
3 is also legal heir.
Class 1 legal.
Mother-
Class 1.
Mother can be legal.
Mother class 1.
Yes, class 1.
Mother, dependent mother, na? Dependent.
No, dependent mother, no.
Your father is alive.
Alive.
Whose father?
They have also a son.
Whose father?
Earning son.
Your husband is alive.
Yes, he is alive.
He is alive.
Huh.
So, so what is your ground? You are saying that you should only get the
My lord.
not the mother.
No, my lord.
Mother should not get it.
Yes, my lord.
Okay, please argue. I now understand your case.
I have gone through the judgment of this Honorable Apex Court, my lord.
Hmm.
My lord, see kindly see.
Hmm.
Validity of nomination.
Yes.
Section 39 of Insurance Act 1938. Whether a nominee of a life insurance policy under Section 39 of the Act on assured dying interest would become entitled to benefit interest in amount received under policy to execution of heirs of assured held. A mere nomination made under Section 39 of the Act does not have effect of conferring on nominee any beneficial interest in amount payable under life insurance policy on death of assured. Nomination only indicates hand which is authorized to receive amount on payment of which insurer get a valid discharge of its liability under policy. Amount, however, can be claimed by the heirs of assured in accordance with law of succession governing them. Hence, appeal is allowed. My lord, I have gone through another judgment of Honorable
Sir, come to the, this is placitum reading.
Ma'am.
I don't like this placitum reading.
Ma'am.
Come to the paragraph, and which paragraph it says, you should read that.
Ma'am.
What is it? The placitum law student ପିଲାଙ୍କ ଭଳିଆ କାହିଁ ହଉଛ?
My lord. Paragraph 12, my lord.
କିଏ ଗୋଟେ ଲେଖିଥିବ edit କରିଥିବ ତାକୁ ପଢିବ.
Paragraph 12, my lord.
Show the paragraph.
Paragraph 12, my lord.
Paragraph 12.
May I read it, my lord?
Yes.
Moreover, there is on other strong circumstances in this case which dissuades us from taking a view contrary to the decisions of all other High Court and accepting the view expressed by Delhi High Court in 2 recent judgments involved in the year 1978 and in the year 19...
ପଢନ୍ତୁ ତ ଲେଖା ହେଇଛି ଟିକେ ଢଙ୍ଗରେ ପଢନ୍ତୁ. Delivered, not involved କହିନି. Delivered.
Delivered.
ଠିକ ସେ ପଢନ୍ତୁ.
In the year 1978 and in the year 1982. The Act has been in force from the year 1938 and all amongst all the High Courts in the India have taken the view that a mere nomination effected under Section 39 does not deprive the heirs of their rights in the amount payable under the life insurance policy. Yet, Parliament has not chosen to make any amendment to the Act. In such a situation, unless there are strong and compelling reasons to hold that all these decisions are wholly erroneous, the court should not be slow to take a different view. In the reason given by the Delhi High Court are unconvincing. My lord, we therefore hold that judgments of Delhi High Court in Fauja Singh case and in Mrs. Uma Singhal's case do not lay down the law correctly. They are therefore overruled. We approve the view expressed by other High Court on meaning of Section 39 of the Act and hold that mere nomination made under Section 39 of the Act does not have the effect of conferring on the nominee and beneficial interest in the amount payable under the life insurance policy on the date of the assured. The nomination only indicate the hand which is authorized to receive the amount on the payment of which the insurer get a valid discharge of its liability under the policy. The amount, however, can be claimed by the heirs of the assured in accordance with the law of succession governing them. I have gone through another judgment of Hon'Ble Madras High Court, my lord.
Right copy. You copy.
Let me-
Which paragraph?
Paragraph 14, my lord.
14.
My lord.
Citation कब का है?
Citation of
23.
16 and 23. Last issue to be taken up as to whether the petitioner and or her
pagination, page signature.
paragraph 14.
Paragraph 14. 21.
Last page, my lord.
Oh,
This one.
yeah, when post correct.
Shakti Murgeshwari. Shakti Murgeshwari. Yes, right.
The last issue to be taken up is as to whether the petitioner and her son will have to once again go through the process of initiating recovery proceeding against the third respondent if in this case the third respondent does not hand over the sum assured to them in the instant case, as between the petitioner and third respondent, it is the petitioner and her son are entitled to receive sum assured as class 1 heir, legal heirs. The Hindu Succession Act that governs the parties make it very clear that the class 1 legal heirs will be entitled to take the share absolutely to the exclusion of the other legal heirs. The third respondent, who is the brother of the deceased, falls under the category class 2 legal heirs, and therefore he is excluded from succeeding to the sum assured. Hence, in the absence of any dispute on the status of the parties, this court, in order to render substantial justice, direct the second respondent to hand over the entire sum assured to the petitioner. It is brought to the notice this court that the original policy is with the third respondent. The third respondent shall submit the original policy to the second respondent within a period of 2 weeks from the date of receipt of the copy of the order. On receipt of the same, the second respondent shall hand over the sum assured to the petitioner and her son within a period of 2 weeks. Thereafter, subject to petitioner fulfill the other formalities.
Okay. Or anything else? That's all?
That's all, ma'am.
Okay, sir.
Please, my lords. My lords, what my learned friend has quoted, these are the judgments, and particularly the judgment of Sarbati Devi versus Srimati Usha Devi, passed by the Honorable Supreme Court. It was passed in the year 1983. And the subsequent judgment also do not lay down the law.
So anyway, you show me something that laid down the law.
Yes, I'm showing, my lords. The Insurance Act 1938 has been amended by way of an amendment in the year 2015. And by way of that, a special exception has been carved out in favor of some of the nominees.
Where is that shown?
Please, my lords, but act is there, my lords. May kindly have the copy of it. My lords,
Section
39(7). Section 39, clause 7. Yes, the general law. Yeah. 39, my lords, may kindly first have 39(1). The holder of a policy of life insurance on his own life may, when affecting the policy or at any time before the policy matures for payment, nominate the person or persons to whom the money secured by the policy shall be paid in the event of his death. This is the general law.
Okay.
My lords, may kindly see. But this is this has now in the then existing, when the Honorable Supreme Court passed the order, this amendment had not come. Now the amendment has come in the year 2015, and by way of this amendment, clause 7 has been added. This subclause 7 carves out a special exception in favor of some of the nominees. that if these persons have been made nominees,
Please read the section.
please,
7.
my lords. 7, clause 7.
Hmm.
Subject to the provisions of this section, where the holder of a policy of insurance on his own life nominates his parents, one, or his spouse, or his children, or his spouse and children, or any of them, the nominee or nominees shall be beneficially entitled to the amount payable by the insurer to him or them under subsection 6, unless it is proved that the policy holder of the policy, having regard to the nature of his title to the policy, could not have conferred any such beneficial title on the nominee. So, my lord, this provision has come into being, and my lord, in my case, I had taken the policy in the year 2017. I got married to the petitioner number 1 in the year 2016. I was a working lady. I took the policy in the year 2017. I paid the premium continuously, uninterruptedly, and it continued up to the year 2023 when I developed, the deceased developed the cancer, and she passed away on 16th of October 2023. So clearly, the amendment applies to me.
So, you are the mother of the.
I am the mother of the deceased policyholder.
Policy.
And
the policy was, it was purchased much before the marriage.
No, it was purchased. That's what I am saying. I got married in the year 2016. I purchased the policy in the year 2017.
Okay.
And I continued to pay the premium. And the later.
Who? You are the dead person.
Sorry. The policyholder. The policyholder. Sorry.
If you say I thought the mother was paying.
The policyholder continued to pay the premium. And I am squarely covered by this special exception. Why this is has been carved out? There is a background to that. Because in what used to happen, as per the general law, that when a person makes one person the nominee, but when the person dies, then all other.
If you are any legal heir and you are the nominee, it's a class 1, there are class 2 legal heir. If there is some entitlement. That's what you say.
No. Now there is no entitlement. If these persons are the nominee, they will take absolutely 100% and to the exclusion of all the other legal heirs. Now the law has been amended and this has been created, a special exception has been carved out.
Here, what I understood from this 7, you are the mother. You are the mother. The legal heir of the here. Let's go to 7 again.
Please.
Read it.
7 again. Subject to the other provisions of this act, where the holder of a policy of insurance on his own life nominates his parents, 1, number 2, or his spouse, or his children, or his spouse and children, or any of them. The nominee or nominees shall be beneficially entitled to the amount payable by the insurer.
You to say the mother will also get.
Not also. Only she will get.
No.
Yes.
No, the 7 doesn't.
No, my lord, this is.
What about the spouses?
No, please, my lord.
What about the spouses?
Which spouses?
Here, 7.
Let us read, my lord. Sorry, yes. I am not able to convey to the Honorable Court.
No.
Madam, let us where the whole
nomination. See. Come again.
Please.
Subject to the provision of this section, there is the holder of a policy of insurance on his own life.
Yes.
Nominates his parents.
Yes. Or there is or. There is or.
Or his spouse.
Or his children.
Or his children.
Or his spouse and children.
Or any of them.
Or any of them.
Nominee.
Or nominees
shall be beneficial entitled. Beneficial entitled doesn't mean only. What is the only?
No, kindly see. Or nominees shall be nominee or nominees.
Not only.
No, please. This is what is the intent and what has been.
No.
Now we have to.
Here, sir. Yes. Where is the word only is there?
Yes.
Not only.
Yes.
Maybe the beneficial interest you may be having.
Please.
But there is no only.
Please.
Yes.
No, what I'm saying, there is no only in the statute, but let's may kindly see the background.
Why should
No. Yes, because, madam, may I submit? Because there is a background to it. And this section has been amended and this exception has been introduced on the recommendations of the Law Commission.
Maybe, sir, Law Commission recommend kare. I am not on that.
Yes.
I am asking How can you say that you are the only?
Yes, my
My
lord.
question is that.
Yes, my lord. I'm saying, and I am relying upon.
What is the background? Tell me.
Yeah,
And what
the
background is
background-
all, then they should have put only also.
Please, my lord, kindly see.
Tell me the
Because,
background.
no, my lord.
What
kindly
is
see
the background
that-
you're saying?
Just background is, my lord, may kindly see the background is.
Yes.
This issue came up, has been dealt with for the first time after the amendment by the Delhi High Court for the first time.
Forget it. You are saying
No,
some
no.
background to this law commission.
This is what I'm saying.
Why the law commission?
This is what
took up
I'm
the issue?
saying. My lords. The Delhi High Court for the first time quoted the report of the law commission, and I'm showing that to my lords. My lords, may kindly see. I'm giving a copy. Shweta Singh. Can I pass it on, my lords?
Yes.
In this case, Shweta Singh was the wife and nominee of the deceased. Was the nominee and wife of the deceased. So, my lord, and Srimati Santosh is the mother of the deceased. Santosh Huria filed a suit of partition and for rendition of accounts and other and also the proceeds of the share in the proceeds of the LIC policy which the deceased was holding in his name. She filed a partition suit. In that partition suit, the lady, the nominee lady, wife of the deceased, she made an admission in her written statement that I have got the proceeds of the 2 LIC policy in the name of my husband, and that is to the tune of rupees 2 crore something. Then the plaintiff, Santosh Kumari Devi, she moved an application under Order 12 Rule 6, that is a judgment on admission. The London Trial Court passed a judgment on admission that yes, there is an admission. So now this lady came up, Shweta Singh came up in appeal before the Honorable Delhi High Court, and Delhi High Court, while dealing with the, now, Amar, may kindly see, first at 27, page 4, Sarbati Devi of the Honorable Supreme Court law has been quoted. Sarbati Devi has been quoted in extension.
No, I'm not.
Well, I'm coming, Manoj. I'm coming.
I only one question. Is it the only beneficial interest here or other people will have also? That is the only question I have.
Please, Manoj, I'm coming to the law commission's report. May I kindly have page 6. Page 6, Manoj.
Yes, I'm there.
Page 6, I'm at the top. This nomenclature 30, serial number 30. Section 39 was amended by the Amendment Act and pursuant to the recommendation of the 190th report of the Law Commission, relevant passages from which are as under Law Commission's views. These are the Law Commission's views, my lords.
Please read that.
Okay. No, I'm coming to the final views of the law because there was a view invited from the other stakeholders also. And now further down, final recommendation of the Law Commission in regard to Section 39. My lord is there?
Yes.
Further down, 7.1.14, after considering all the responses and re-examining the entire issue, the final recommendation of the Law Commission regard to 39 may be summarized as under. A, clear distinction be made in the provision itself between a beneficial nominee and a collector nominee. B, it is not possible to agree to the suggestion made by some of the insurers that in all cases the payment to the nominee would tantamount to full discharge of the insurer's liability under the policy, and that unless the contrary is expressed, the nominee would be the beneficial nominee.
Yes.
C, an option be given to the policy holder to clearly express whether the nominee will collect the money on behalf of the legal representatives. In other words, such nominee will be the collector nominee, or whether the nominee will be the absolute owner of the monies, in which case such nominee will be the beneficial nominee.
Okay.
D, a provision be added to make the nomination effectual for the nominee to receive the policy money in case the policyholder dies after the maturity of the policy, but before it can be encashed. Suggested amendment of Section 39. To give effect to the above recommendation, the Law Commission is of the view that Section 39 be recast as follows. And this is the language which has been adopted by the Parliament.
But in the entire reading, my answer is
No,
not
please,
available.
it will come, my lord, it will come. Please bear with me for
No,
a
I
minute.
have bear with you.
It will come, it will come.
Yes.
Then this is the recommendation which has been taken from the law commissions itself.
Fine.
Subject as aforesaid, where the nominee, if there are nominees, then one, a nominee or nominees to whom subsection 7 applies, die after the person whose life is insured, but before the amount secured by the policy is paid, then it is not relevant. But may kindly come to the next page, page 7, paragraph 31.
Yes, I'm there.
As is evident from the reading of the recommendation of the Law Commission, a distinction was carved out between beneficiary nominee and collector nominee. And section 39 of the Insurance Act 1938 was amended accordingly, adding subsection 7. Beneficiary nominee means a nominee who was entitled to receive the entire proceeds under an insurance policy, and a collector nominee means a nominee other than a beneficiary nominee. Keeping this distinction in mind, subsection 7 of section 39 was carefully and cautiously drafted, and the words used by the legislature are beneficial interest.
Yes.
Beneficial interest.
Can you say that the wife and the father and the child doesn't have beneficial interest?
Yes.
How?
As per this amendment,
where is that?
Please, I'll come. What is beneficial interest? That has also been further interpreted by the Honorable High Court. What is beneficial interest? That has also been further interpreted.
Okay, please go.
32. Perusal of the impugned order of the trial court shows that the appellants had brought the 2015 amendment to the notice of the trial court, including judgment of the Rajasthan High Court in Ram Gopal versus Ram Gopal Supra. But the trial court has not even dealt with the legal issue raised before it and allowed the application under order 12 rule 6 based on the unamended provision of section 39. It is settled law that the rights of the parties to the list have to be decided in accordance with the statutory provisions and law that prevails on the day of the cause of action arises. Now, 33. In the present case, appellants had specifically flagged the issue of applicability of section 39 on the ground that Le Shri Vineet Huria died on so-and-so, and the policy had matured after the amendment to section 39 came into force. It was thus incumbent upon the trial court to have considered and examined the issue once the same was raised and highlighted by the appellants and taken a decision accordingly with respect to the benefits accruing under the insurance policies in question. So, observing this, the Honorable High Court remanded back the issue to back to the trial court. So now, but thing is, what the Law Commission had recommended is that a special exception has to be carved out. A distinction has to be made between the collector nominee and a beneficial nominee. And beneficial nominee, what is beneficial nominee? May kindly see this issue of beneficial nominee has come up again before the Honorable High Court of Andhra Pradesh. And this has been Malela Manimala. Can I pass it on?
Yes.
So, in this case, the Malela Manimala was the legal heir. And Malela Lakshmi was the wife nominee. In this case, Malela Manimala was the mother of the deceased policyholder, who is the writ petitioner before the Honorable Court, and Malela Lakshmi Padmavati was the nominee, wife of the deceased policyholder. And now these facts have been discussed at page that he was, he died during COVID, and the total amount, may kindly have page facts have been, in brief, they have been called out.
What happened in this case? What is the final
I'm coming to the law. I'm coming to the law, matters.
Yes.
These are the arguments of the parties. May kindly may permit me to read from the top of the page 4. It is argued that the amended section 39 of the Insurance Act will not override the right of succession of the class 1 heirs enshrined in the Hindu Succession Act. It was argued on behalf of the appellant, writ petitioner, mother, legal heir. Per contra, the argument advanced on behalf of the respondent number 123 is that the 123 the wife nominee. is that the concept that a nominee is mere collector and a trustee on behalf of all the legal heirs who are entitled to a share in the estate of the deceased has undergone a sea change with the amendment of section 39 of the Insurance Act 1938 by virtue of the Insurance Laws Amendment Act 2014. Inasmuch as section 7 of amended section 39 facilitates a holder of an insurance policy to specify any one or more nominees among his parents or spouse or his children as beneficial nominees to be entitled to the insurance amount in exclusion to others. Learned counsel emphasized that in the instant case, since the deceased has shown his wife, that is the first respondent, as the beneficial nominee in the two insurance policies, she alone in exclusion of other heirs will be entitled to the insurance amount, and therefore the petitioner cannot lay any claim over the insurance amount and seek a direction to the fourth respondent, that is the LIC, which issued the LIC company which issued the policy in that regard.
Malala Manimala, with that, with the how the relationship with the deceased here?
Yeah, deceased Malala Manimala is the mother of the deceased, of the deceased, and Malala Lakshmi is the wife and nominee of the deceased. He took two policies. He had taken two policies, and in two policies he had made his wife as the nominee. And now, after his death, the mother moves this writ petition, and now the issue of interpretation of the section of the amended section 39(7) comes. Now, these are the arguments. Now, what the view is taken and what is the logic behind given by the Honorable Court is, now again, my lord, the amended act and the unamended acts have been quoted, so that is not in dispute. And what the learned the Honorable Court has found is the discussion is at page 9. May kindly have page 9 of this judgment.
Yes.
Discussion of the arguments is a careful perusal of subsection 7 of section 39 would indicate that words beneficially entitled are employed for the first time in subsection 7 of the amended section 39, which we do not find in the original section 39. In my considered view, the legislative intendment is manifestly clear from the words beneficially entitled, which means the nominee or nominees shall receive the insurance amount on the death of the policyholder in her own interest in exclusion of other heirs. My view gets fortified from the interpretation given to the words beneficially entitled in the treatise The Law Lexicon by renowned author Shri P. Ramanatha Iyer in his second edition. The words beneficially entitled are defined as follows. Beneficially entitled to possession does not mean entitled and deriving a benefit from possession, but beneficially entitled in the sense of being entitled for one's own benefit if there is any benefit to be derived from the estate and not simply a trustee for others. The above narration precisely tells that a person who is authorized to be beneficially entitled to an estate means he will be entitled for his own benefit. Then it otherwise stipulates that the said person excludes other from the enjoyment of the estate. When this meaning is imported to section 39(7) of the amended act, it gives an understanding that the registered nominee or nominees after the death of the policyholder shall receive the insurance amount for his their benefit enjoyment in the exclusion of other heirs. This legal aspect is no more res integra. Then Ram Gopal, General Public, High Court of Rajasthan is also quoted. And in that also, this view has been reiterated. I am at page 10, top of the page 10. As per the decision of the Honorable Supreme Court relied upon by the learned counsel for the appellant, the nominee of insurance policy receives the insured amount and the legal representatives of the assured can claim their share as per the succession. However, in the year 2015, amendment has been made with a Insurance Laws Amendment 2015, and as per the same, the nominees alone gets the amount on account of death of the insured. No other person can raise a claim with regard to the said amount. 39(10) of the said act added by the Amendment Act lays down that the provision of subsection shall apply to all policies of life insurance maturing for payment after the commencement of this act. In the present case, the policy it was held in favor of the nominees.
Okay.
The may kindly have para 13.
Please give a note. I understood.
Please, madam.
Please give a short written note.
I'll be giving a brief note.
We are for the insurance.
Yes, my lord. I'm for OP number 2.
We have no.
They have
Do one thing. All of you give me a short note.
May I once again read the judgment of the Madras High Court, my lord?
Sir, it's a Madras High Court, my lord, what my learned friend is quoted, that favors me. He has quoted Shakti.
Justice Anand Venkatesh judgment.
Pardon, madam?
This is judgment of Justice Anand Venkatesh.
And Anand Venkatesh.
But in that case, what was the nominee was the brother.
I know.
So, but this was not the exception. He was not coming to 39-7.
Please, all of you give me a short note.
So,
Case law you have
so
already given.
this judgment favors me.
Okay, good.
Huh?
Give a short note, sir. All of you.
Not going, not for today.
53.
Not for today.
Please,
Other party,
I'm so much obliged, my lord.
Other party.
Obliged, my lord.
Already adjourned.
Opposite party time.
Obliged.
10th of July.
Sir, please send your note to the junior.
Please.
By what time will you give? Monday?
Yes, within a week, my lord.
Within a week.
I can send it by because I have to go fly back.
No, you fly back. You can mail it to your leader. You can,
Sure.
Lordship, may I post it
or you
to
can take his email ID, you can send it.
Sure. I'll do that, my lord.
Item 57, my lord, during first hour, my lord granted.
Please don't.
No, my lord granted liberty to come and mention that after taking consent from Mr. Mahanti, senior counsel. I have already taken consent and they have no objection, but he wants that the interim to continue till that.
my lord, item
41, I have.
Lordship,
Sorry.
Next speaker.
Maybe 27.
Item 24, item 27.
Yes.
Pass the over matter, item 22.
52. Non-APS.
For the opposite party number 3, my lord.
Non-APS for the police. 27.
Item 29.
9.
May I please, ma'am? Well, in this case, the basic challenge is that the opposite parties in violation of the Airport Authority of India Act have discriminated against the petitioner. Your Lordship, the conspectus of the case is the Civil Aviation Department created International Airport Authority of India in the year 1972. 71.
How that creation of year is important, sir. Come to the point straight.
Minor. Just to
When it was created, all this, why should I go to the history?
slight
What is the
relevant.
problem?
Problem
Come
is
to the problem straight.
Your Lordship, International Airport Authority was created. After that was created National Airport Authority. These were the two branches. In the two branches, there were one cadre post that is called the housekeeping cadre. In the International Airport Authority, the housekeeping cadre had a qualification of graduation, science graduate with 1 year diploma or 3 years diploma, 1 year diploma in sanitation or 3 year diploma in hotel management. So with that qualification, the petitioner and his likes in the International Airport Authority had joined. Now in the National Airport Authority, there was a post of caretaker for which the qualification was only matriculation. So therefore the joining was the International Airport Authority was at a higher level and at the domestic National Airport Authority, it was at a lower level. And the caretaker post in the International Airport Authority had a promotional avenue up to 3 ranks.
Now,
Whereas
what
in
is your problem?
my lord, just in a minute it will be clear, Your Lordship. In the National Airport Authority, there was no promotional avenues. Now, in the year 1994, these two branches were merged together and Airport Authority of India was created. And this was done by a parliamentary act. And there were 3 committees that were constituted who looked into the issue of inter-se seniority between these domestic National Airport Authority employees and International Airport Authority employees. And after the 3 committees recommended, comprising senior person, including Justice Jain and Krishnamurthy, these committees. So a common seniority list, a common cadre was prepared based on their positioning in the year 2005. And a common rule for recruitment and promotion was also promulgated in the year 2005. Now, Your Lordship, what happens? In the year 2014, the Airport Authority of India gives promotion to those who were appointed at a lower level in the National Airport Authority, ignoring the higher position, those who came with better qualification and were positioned in that common seniority list much higher. Ignoring them, they gave promotion to those who were part of erstwhile National Airport Authority. Now, their contention is that this merger had never happened. In their counter, they are saying that this merger has never happened, whereas it has been categorically proven through
Airport Authority.
So, therefore, the documents are clearly proving that the merger had taken place in the year 1995. They have taken the position that the merger is final. Now, in order to justify their illegal act, they are saying that International Airport Authority was never merged together with the terminal management, which was later created. This is the basic position, Your Lordship. Just to kind of give the comparative, Your Lordship may kindly come to page number 11.
Yes.
My Lord, in this case, the Timmy Biswas is the petitioner number 1. He belongs to the erstwhile International Airport Authority division. He joined in the year 1990, dated 21st 9 to 1990, with the qualification of graduation in science and 1-year diploma in sanitation. Now, his counterparts in the National Airport Division, the other 2, they had joined with a matriculation qualification at a much lower level. And there was no promotional avenues in the National Airport Authority. But only because of the merger in the year 1994, they were brought to the level of the petitioner. That is in 1994. After that, if your Lordship peruses, in 1996, the petitioners, they were promoted to the non-executive rank of 9, and they were to be, the common gradation list was prepared in 2005. He was supposed to be placed in the executive rank in the year 2002. And the National Airport Authority counterparts were to be eligible in the year 2008.
Your grievance is with respect to the promotion.
My promotion and career advancement of these 2 categories.
What are the hierarchy here?
The hierarchies are they're given there. It is non-executive, then executive rank, up to general manager. They can go in the terminal management. Your Lordship may kindly look at the column number 8. I and my likes in the International Airport, erstwhile International Airport Authority Division, we were eligible to be placed in the executive rank in the year 2002. Whereas the National Authority people, they were to be eligible from the year 2008. Whereas in violating the entire thing, they have granted promotion to the erstwhile.
Tell me one thing. Was there any merger actually? I
Yes.
don't think there is any merger.
There was a merger. There was a merger by the Act. Your
What is
Lordship,
that act?
my Lord,
To me.
1994 Act. Your Lordship may kindly turn to page number 10. Page number 9 to begin with. The bill. My Lord.
Bill, why are you showing bill?
No,
It's for the act.
The Act is the
Bill
next
and
page. No, not the next page. It's a continuation. Your Lordship, in the bill,
Page.
page number 9. Only a paragraph.
Page number 9.
My Lord.
In the read.
My Lord.
But that is your code, sir.
Yes.
I want some document. Where is that act? Airport Authority Act.
That, yeah. The preamble, yeah. Preamble of the Act can be read out.
You can read that?
Yes.
Not preamble, SOR. Statement and statement of an object and reasoning.
My lord. Statement of the objects, your lordship. Yes, your lordship. 4, page number 2, your lordship. Constitution of a single unified airports authority of India to control and manage both national and international airports in the country and transfer and vesting of undertakings of the International Airports Authority of India and National Airports Authority of the said Airports Authority of India. So this is the merger, the Airport Authority of India Act, wherein the International Airport Authority and the National Airport Authority were merged.
No,
And
where is the merger? I need to find the merger.
well, this is what it is saying, that all the vestings transfer.
Which paragraph?
Page number 4, paragraph now, salient features of the bill.
Why are you reading bill, sir? Come to this act.
My
When act is already there, why are you
My
reading
lord.
bill? Bill में क्या रहा है?
Yes.
Bill already मर चुका है.
Well,
Act जब हो जाता है, bill का कोई अस्तित्व नहीं है.
No, that's true. Yes. Yes. The very first paragraph of the act, your lordship. An act to provide for the constitution of the Airports Authority of India and for the transfer and vesting of the undertakings of International Airports Authority of India and the National Airports Authority of India and in the Airports Authority of India so constituted for better administration and cohesive management of air.
Vesting means they have been.
Yes, they have. And this position is consistently taken by the opposite parties.
So what is the problem? They are saying what?
My lord, the problem is the National Airport Authority had a housekeeping cadre. The International Airport Authority had a housekeeping cadre. The International Airport Authority, the petitioners and his likes had joined with the qualification that is graduate, science graduate with 1-year diploma. Now the domestic, the National Airport Authority, the same caretakers, they were appointed with a matriculation qualification, and there was no promotional avenue for the National Airport Authority. But there were 3 promotional avenues for the International Airport Authority.
So what is your problem?
That's what I'm
You
saying.
belong to which category?
International Airport.
International.
My lord.
All are international. All
My lord.
petitioners are international.
My lord. My lord.
So when the new authority AAI came into existence,
My lord.
you have been brought into the AAI.
Yeah.
Right?
It's a common cadre. Common
You have
cadre
been
was framed.
brought into the AAI, and then what?
That's right. So by that 1994 Act, by the merger, those who were working as housekeeping in the National Airport Authority, they were brought to the level of the housekeeping to the petitioners level. After that, what they did, they promoted those who belonged to the erstwhile National Airport Authority, and they didn't promote the International Airport Authority people.
But what are the posts from the National Airport Authority? What are the posts they were promoted to?
They promoted, your lordship. That is what is at page number 11, your lordship.
What is the
Yes. Promotion to assistant manager. That post was not to be occupied by, had there been 2 divisions, National Division and
that division, now the division is no more there.
no more there.
Now it is a common cadre.
Common cadre.
So in common cadre,
Yes.
so what is your next post?
I should have been promoted to assistant manager.
Assistant
Manager.
So you are saying you have not been considered, whereas the people who came from the
National yes.
Airport Authority.
And after doing that, they are saying that now it is demerged. That's what is the crux. That a merger which has been effectuated by the act of the parliament, now they, after giving promotion illegally to the erstwhile National Airport Authority employees, are saying that the merger didn't happen. That is what is the crux of the problem. I will demonstrate before your lordship in this honorable court in the year 2010, through an affidavit, the airport authorities have admitted that the merger is complete and merger has taken place. And there are documents, your lordship, all the documents are there, Annexure 3, Annexure 4, Annexure 5, which clearly shows that the 2 divisions were merged and they were made part of the terminal management. Now they are saying, no, only the National Airport Authority was merged with terminal management. The International Airport Authority people were not included. That is the question, your lordship. But the common seniority list was prepared on the basis of their positions as as on 2005, because that is the year.
Your heartburn is because you are highly qualified, you are in the international division, still
No,
we are not given.
After that, a common seniority list was prepared. In that seniority list,
Senior, you are also senior.
yes, I am in 6th position and they are in 12 and 13.
The 12 person got
People have been
promoted
given
to-
promotion and I have been ignored.
What is the answer, sir?
This matter actually relates to a particular prayer matter. When the prayer says matter is something different, as it has been presented to us. The prayer is that matter, they are against the principle of merger initially, as they had pointed out in the previous paragraph up to para number 18. Thereafter, matter, they told that matter that because of demerger, once again they are also. So now it is a case where they are agreed, they are saying that agreement both with the concept of merger, so also married with the concept of demerger. Now, with respect to petition number 1, because with territorial, with respect to the scope of territorial jurisdiction, with respect to the petition number 1, I am making a submission matter in this case. That it is a submission by the petitioner that the petitioner belongs to housekeeping care. Annexure 5 to the writ petition this says that in the year 2008, the housekeeping cadre has been abolished.
So,
They are claiming
so housekeeping cadre in the international segment.
no,
Hmm.
Madam, that is only one cadre.
Okay.
Now, because of its merger with the terminal manager, thereafter, madam, it has named in other way. And now, what they are claiming that taking into consideration our previous status, because we have not been perfectly inducted to the cadre, as it has been done in case of NLE questions. So that is the reason we are agreed on. Now, if that is so, madam, and all the actions were taken in the year 1995 up to 2006. There is no specific challenge to any particular order in this case. The petitioner has also got his promotion in his own name. They got their promotion in their own. There are two different promotion charges. So, according to the merger policy, the manner in which manner they are supposed to get their right to get for consideration for promotion and to get promotion in their own hierarchy. That has been done and that has been given to them. Now, since it is a case of merging by way of and by way of merging, when two sets of people are existing, I may rely upon the decisions of Hon'Ble Appellate Court in the PUGC case hospital, wherein it has been stated that in case of merger, there may be some person who may be affected. But once it is effectively merged and it is a policy decision, then merely because some person is affected, that merging decision cannot be interfered with. In this case, there is no specific statement with respect to any denial of their promotional avenue or curtailing their promotional avenue. Their sole stand is that the manner in which actually they have been inducted to the cadre after merging, in comparison to the other category, they are in a better position in comparison.
Okay.
May I please, ma'am? My lord, just to clarify the what my learned senior is.
Understand, sir.
My lord.
Okay.
Okay.
I'm sure.
Just needs one clarification because what my learned friend said is untrue to the extent that we are not objecting to the merger. We are not objecting to the merger. Rather, we are saying that after merger, there is the common gradation list has been prepared. In that gradation list, I figure in 6. And the people who were earlier erstwhile part of erstwhile National Airport Authority, they are ranked 12 and 13. My only submission is that since that is as my friend is admitting that merger is complete. Now I am thankful that he is admitting that. Whereas in his counter, they are saying that merger was never taken place. So
Okay.
my only
Give a note.
my lord.
I have wasted.
26.
Along with case law, everything.
My lord. Obliged.
Item number 38.
Eight. 38. 9, 38. Non-APS. That's the matter. 28, 39.
39.
Insurance matter and the petition has received day before yesterday the check.
No, nothing
My
survives.
letter order
Nothing
dated-
survives.
Eh?
You have received the check, nothing
As
survives.
My client is informed me morning
Hmm.
that he has received the check.
So now nothing survives.
Nothing survives.
We will learn consider the petition submitted that he has already received the check amount. It's awarded.
No, your lordship has directed that no, I will not dispose of, you pay first. The sum insured under the policy, accordingly, 2 rupees 2 lakh has already been paid.
And next.
Item 43.
May it please your lordship. My lord, I am 43. I am for the petitioners, your lordship. Petitioner, single petitioner. I have filed a rejoinder in this case on 18/6/2024. I will serve a copy to my learned counsel appearing for the bank. I will serve a copy by next date. I will serve a copy. Your lordship may call for that rejoinder. That has not come to the record also.
My lords, they may serve the rejoinder to me and let the next date be fixed because there is a stay operating against us.
Yes, your lordship. I will serve the
I'm
copy.
giving a short date, 2nd July.
My lord.
1st July, there is bank day.
My lord.
Bank day.
So my lords, is it first or second?
1st July.
My lord.
Obliged.
Lord, the interim order may continue till that date.
My learned friend may serve me the copy today itself.
Yes. Yes, I will serve.
Obliged.
You take her email ID, you can send it.
Copy दे देगा, hard copy भी
It's
दे
there
देगा.
on the counter, my lords. My email ID and phone number both are on the counter.
Mail it.
आगे दे देगी.
Obliged.
Next.
Obliged.
Item 44, written submission has not been sought.
Written submission क्यों serve करे भाई? Written submission कोर्ट के लिए आपके सर्विस की जरूरत नहीं है. Why are you unnecessary written submission आप एक डिटेक्ट नेबे?
मतलब देना है, copy serve करना है.
Written submission
let me plead. Your lordship, I am for
written submission देवार का बाध्य नु. एटा just एटा read petition एवढा का written submission देवार बाध्य नु. हाँ आपण से तळ कोर्ट रे जो करिवे सेते ठीक
Copy
है.
serve करना मत देना है copy. वो petitioner. I am for
I have not filed it yet, my lord.
Sir कहारा copy?
opposite but now 2 has filed. Written.
Written note submission ना counter affidavit.
ना written submission लिखा है.
Written submission पे
Counter affidavit, what it means, my lord. I am for OP number 4.
That is for assisting the court, not for this.
Lords. I am for OP
They
number.
parande, no they parande. Yes.
I am for OP number 4, my lord. I have interappearance. I think 2 to 3 days back I have filed the wakalatnama.
Petition nandi, apna.
Petitioner.
So, my lords, your lordship may fix a short date so that I'll file counter.
हम लोग ना this adjournment is just a culture. Just please share this.
Your lordship, I have
nonsensical
I-
culture.
Your lordship,
Unnecessary. Everybody is asking for time only. Why am I here then?
this is my first appearance.
Yeah, your first appearance, second doesn't matter. to me.
Lordship, kindly hear me, my lord.
Every time somebody asks, sir, I am trying.
I was intimated.
Council ये हो गया.
I was
वो हो
intimated.
गया. What is this going on here?
I'm really sorry, my lord. I have I was intimated by about this case only a week ago. So your lordship, I have already the counter ready. I just need the annexures. I am yet to receive them. Your lordship may fix a short date. In the meanwhile, my lord, I have also filed an IA, my lords. I have filed it today. Your lordship, your lordship, go into the merits of the case. Your lordship,
What is the IA for?
your lordship, I am the insurance company and they have certain claim against us.
Insurance company, what is the
They
IA
have
for?
certain claims against us. And your lordship, while the case is still pending, the petitioner and his accomplices are time and again harassing us over social media. That is damaging our goodwill in the market. So your lordship, I have
goodwill.
My lords, I have filed an IA with.
Goodwill होगा तो damage होगा. आप लोग तो goodwill खो चुके हो.
I have filed an IA with a prayer to direct them to refrain from.
I'm not going to pass anything next date.
That's why, Your Lordship, kind of
23rd
fix a
July.
short date so that I'll get into the
23rd July,
merits.
no short date. The time मागिबो तम हिसाब time राम हिसाब time दे. Short
Obliged,
date.
my lord.
Time भी मागिबो short date भी दरकार हो. Next.
Obliged,
23rd July. 23rd July.
23rd July.
Obliged.
45.
ଏବେ जे time मागिबो आगो 500 टका एटी जमा करियो तबरा time मागिबो. हला. जे भी time मागो. I'm not going to spare anybody. 500 rupees. What is that? Otherwise, arguing people never smile. Serious as you. The hosses time making. You're asking for time, na?
Yes, my lord.
Yeah.
My lord, we received the counter day before yesterday and we need time to file
This
the
is
rejoinder.
2024.
My lord, I may be excused. In this matter, I am appearing for the opposite party numbers 2 and 2 to 4 insurer company.
You have filed the counter.
I have already filed, but it appears it is not tagged to the record.
When did you file? When did you file?
On 19th.
19th.
Yes, day before yesterday. And another fact is that 3 more cases are pending out of this common cause of action.
So
All
that,
those.
give the number of all other 3 cases.
Yes, yes, my lord. And
You know
since
the
I have
other
not.
3 cases.
Yes, my lord.
Please give the number.
My lord, since
Give the number and
the copy of the writ petition has not been served on me in all those 3 cases, may I request counsel appearing for the other side to serve a copy?
Give those copy also, madam. Give those
So
copy.
that I will be able to file my counter.
So that he can also file the counter. Give that number, put ma.
Yes, ma'am.
3 more cases.
So list the matter on 22nd July. In
Obliged.
the meantime, any whatever you want to file, file.
My lord,
Okay.
can you 2 weeks time?
22nd July, more than 2 weeks I'm giving.
Oh, okay.
Sufficient time.
Yes, ma'am.
Calendar to dekho. Next.
Item 46.
May I please, your lordship. I am the petitioner, your lordship. In the second round of litigation, in the first round of litigation, the petitioner has approached this honorable court for a
The honorable court says, go and file a representation, and I have been kicked out from there, and I have come here. That's what?
No, your lordship.
Yeah. That is what
My gratuity and retirement benefits were held by the opposite parties, your lordship.
This is what I'm saying. But what happened in the first round? You said you're saying second round.
This is the second round. They have
First round.
First round, there was a direction, and as per that direction,
What is the direction?
direction to consider my representation.
I'm coily भूल गई. Sit them. I can easily guess it. A direction माने किसी ने.
They have
सेटू लाता खाई करे आइबो एठी खाइबो एठी आउडे लाता खाइबो सेठी जीवो सेठी लाता खाइबो पुणी आउडे राउंड आसीबो तो लाता खिया राउंड गुटे खा लाता खिला आउडे लाता
somehow they have disbursed some amount here.
For opposite party number 2 and 3, Baleswar and Bhadrak Central Cooperative Bank, and we want 4 weeks time for filing of counter fees.
कौन सारे टाइम मांगे 4 week टाइम देते हो आगे टाइम मांगे
They have admitted my gratuity.
तो इधर काम खत्म क्लोज करे का टाइम काउंटर रीजन काइन टाइम वेस्ट करछन देबार तार एंटाइटल है दे देबे खत्म.
They have put my gratuity lien. Your lordship may kindly see annexure 1 that is.
Pedantic approach not good. जैसे जोड़ी clear cut case थी वो straight दे देबे. अब इतने counter regional के लंबी के लाभ कौन?
They have admitted that I have retirement benefits of 15 lakhs.
File within 2 weeks. Finish it. Don't delay further. Okay. This is the matter on 18. Land transfer to the bank. Shall file the reply by 18.
May I pray your lordship instead of Mr. Sahani, no, sorry, Mr. Kabiraj Pradhan has been reflected, opposite parties counsel. He was appearing initially, but now they have appeared, their name may be reflected. Next date Pune.
Kabiraj Pradhan.
Again. His name is reflected now.
Whose name you want to be reflected?
Their name, they have appeared afresh.
Different, they are not from the same. Member दे दे ना लिखी दे. Next.
Obliged, your lordship.
Item 47.
Item 47, I'm appearing on VC. Lordship may kindly ignore the noting because I have already served an extra copy and I have the receipt of the same. And my learned senior has already filed his Wakalatnama, he has informed me, and the same his name is not reflected in the cause list.
Whose name?
My learned senior is already appearing.
Who is your
On
learned
behalf
senior?
of the,
Who is your
uh,
learned senior? Who is your
uh,
learned senior?
my
Lega,
So only I.
Simply admission kar de ja.
Yes, sir.
24th July.
grateful.
Bank ର dating ସେଇଆ ଆପଣ ଦଉଥିବେ ସେ ନାଇଁ କହୁଥିବ ଆପଣ ହଁ କହୁଥିବେ ସେ ନାଇଁ କହୁଥିବ ଆପଣ ସିଏ ହଁ କରୁଥିବ ଆପଣ ନାଇଁ କହୁଥିବେ ଏଇଟା ହଉଛି ଡେଟିଂ ପିରିୟଡ ଆଉ ଯେତେବେଳେ ମାନିଯିବେ ଦେବି ସେଟା ଲଭ୍ ଏଫେୟାର ହେଇଗଲା ଆଉ ପୁରା ଯେତେବେଳେ ସାଇନ କରିଦେଲେ ବନ୍ଧନ ଟୁଟ ଗୟା ତାପରେ ଡିଭୋର୍ସ ଯିଏ ଯାହା ବାଟେ ଚାଲ ହେଲା ସବୁଥିରେ ଗୋଟେ ଫେଜ୍ ଅଛି ନା ନେକ୍ସଟ
Item 48.
48
Lord, notice was issued. The Lordship was pleased to issue notice on 25th 4 and notice AD has back after valid service.
service
Valid service.
None appears for the opposite party despite the notice is complete. Let it chance be given in interest of justice to appear in the matter. This is matter. Next.
49.
49. ଆପଣ ଅଛନ୍ତି 49 କିଏ ନା for the bank କଷ୍ଟେଶ୍ୱର କର୍ମୀ कोई नाती की
Civil suit was decreed in 2022.
Decreed whose favor? Your favor? Bank favor?
In the execution process, he has come to this honorable court and filed for a case. Outstanding is 9,82,000. Say something.
None appears for the petitioner. Despite the notice is complete. In the interest of justice. 2 weeks time may be granted to the opposite party. Sorry, petitioner, sorry, petitioner. To appear in the matter. 25th July.
Last item entry model file to
Next.
Item 50.
50.
Yes, no, okay, appeared today.
I appear on behalf of opposite party number 2. My lord, I seek pray for 2 weeks time.
आपण भी सेया कहले कौन समझते खाली टाइम आगे टाइम ने बीमारी लगी जी समझते को ए कर आ गुटे कोरोना एटा
In fact 24 was pleased to issue notice and stay the ex parte award. Yeah, but
nobody appearing.
I am taking appearance today on behalf of private opposite party.
2 and 3.
Only
2. What is your name?
Sukhadev Vilas.
Your name. Your name.
Yes, sir.
Huh?
Yes, sir.
Shubham Sharma appears on behalf of
Opposite party number 2, private opposite party.
private opposite party number 2. How ki rahili baki the?
Lord, first is the chairman permanent local adalat. Taku darkar nahi. 2 and 3. 2 was the matlab mortgager, 3 was the loanee. So 2 had come to the permanent local adalat and got the award. And the my lord, beneficiary of the award of the local adalat.
So 1 person left.
Yes, 1 person left. The person who is the borrower, my lord, he has to also
borrower,
appear.
That borrower notice completed. Borrower. Take a press tape.
Yes, Dave.
Sorry. ଆଉ ଗୋଟେ କଣ
ଆଉ ଥରେ ପଠେଇ ଦଉଛି ଆଜ୍ଞା only to OP3
ହଁ ଆଉ ଗୋଟେ ପଠେଇ ଦିଅନ୍ତୁ
ଆଜ୍ଞା
OP3 ଖାଲି
ଖାଲି OP3 को
Okay,
आଜ୍ଞा
land council
आଜ୍ଞा
petitioner to serve
take steps for fresh
extra copy serve afresh
to OP3 आଜ୍ଞा
OP number 3 by registered post
आଜ୍ଞा
ଆଉ ଥରେ କରି ଦିଅନ୍ତୁ
within next 3
OP3
working
ଟା
days
address ଟା କଣ
OP3 address ଟା आଜ୍ଞा
ମୟୂରଭଞ୍ଜ
बालेश्वर ओ जो ठीक है वो पठे
ठीक है registered post पठेଇ दिଅନ୍ତୁ
आइए
next
my lord interim order is there may I pray till
Interim
next
order.
आइए my lord after a month it will be listed because 30 days notice
Yes, this is better on 31st July.
obligement
Next,
Item 54.
54.
54.
52, somebody has taken that.
You guys
Opposite party. Opposite party. OP number 4.
I have told him actually, please intimate the other side. I always insist, but so he said.
Well, I could not have waited because my matter was over before lunch. I was waiting for this one. Because,
No, because they had that happen.
Bar Council of India is there, I have to be there.
Yeah, I know.
Your
Oh, yeah, I
lordship,
understand because there's some bar council issue.
my lord, your lordship may only direct the registry to say that I have already filed my vocalist number, that may be accepted only.
Okay, Mr. AP Bose. Your name is there.
Name is there, my lord, the noting says vocalist number not filed.
For the Odisha State Bar Council.
No, my lord, I am for the Bar Council of India.
I'm so sorry. BCI, Bar Council of India. It's accepted and the name may be reflected. The name to achieve.
Yes, grateful.
Yeah, for OP2K. OP2 and 3. What is your first name? I'm forgetting. Amitabh Tripathi. But your name? Sobhagya. On behalf of interceptors on behalf of 2 and 3. List the matter on 31st.
Your lordship has fixed to 9/7.
Oh, sorry, 9/7.
Your lordship has already fixed it.
Okay, 9/7. Okay, 15.
Item 54.
May I please? Item 54. I am for opinion number 3 and 4. Kindly serve a fresh copy.
Opinion number 3.
3 and 4.
Three and
Right.
four. Who is for 1 and 2? 1 K.
collector
এটা কোন ইস্যুটা কোন
এটা vehicle loan settlement ପାଇଁ
Husband of the petitioner purchase a vehicle, motorcycle by availing loan from OP number 3.
number 3 କି sir OP number 3 ଅମକ ବି କହିବେ ଖାଲି OP number 3 ବୋଲେ ଆପଣଙ୍କ ମୁଣ୍ଡରେ ଲେଖା ହେଇଛି OP number 3 କିଏ
IDFC
OP number 3 ଯାଇକି ଦେଖିବୁ
IDFC bank.
କହିବି ତ ସିଧା OP number 3 IDFC bank କହିବି
Subsequently he died.
ସବୁବେଳେ ଏଇ ଗୋଟେ କଥା ମୁଁ କହୁଛି OP number 3 ରେ ଚୁପଚାପ ରହିବେନି ତା ସାଙ୍ଗରେ କୌଣସି କୋ ପାର୍ଟି ବି କହିବେ ନା ଆଉ that become easier because every time you can't look into the member parties. That's what I'm saying.
Subsequently he died.
Okay.
Thereafter financer bank enforcing to pay the loan amount, but at the time of availing loan there is a insurance here.
So you want that insurance cover? You are for the insurance company?
Insurance, we are for IDFC First Bank. IDFC First Bank.
You're for the bank? Which
Finance
one insurance company? You have made insurance company as a party? Have you made insurance company as a party?
No.
You are
Like say it as semane
sir, claiming something against the insurance company, will you not make the insurance company a party? When you are claiming against something against the insurance company, you have to make the insurance company also a party, sir. Otherwise, how will you claim against the insurance company? पैसा तो insurance company देगा ना?
आज्ञा. That is their duty to settle. कारण semane loan at the time of availing loan
court को असली party बने भी नहीं. हाँ, court party बने ना. Land petitioner to make the include the insurance company as a party respondent.
And can he
within the period of
give also fresh copy also? Not the entire copy.
और ठीक है fresh copy दे देंगे. बाबा ये जो से छोट छोट जो दिया निया ये जो fresh copy ताकि डायरेक्ट मागे कोर्ट सब कुछ जो करिवो. हाँ, fresh copy टे मागे भी आमु मगे देबी आपन को. काम नहीं कोर्ट बेसी. आपन भीतर दिया निया ही परिबेनी. कोर्ट काई कहबो सब कथा रे. कोर्ट दे कॉपी दे ये काम हम रही गला. कॉपी आपन मागे दा पे. Next. And that is just 23, 24, 25.
Item 55. Lordship, item number 55 for the petitioner, my lordship. In this case, my lordship has on the last occasion has categorically directed the IDBI Bank to file an affidavit stating the reason of delay in returning the above noted documents, that is the original title deeds and the NOC, and the reason why the payment of rupees 5,000 per day penalty shall not be imposed upon the bank.
What is the answer, sir?
My lord, my lord, I have already filed a counter to that effect. May I take your lordship to the petition, my lord?
I just want to know why you have not.
My lordship,
Yes,
if
my
I
lord,
must
I want
submit
to
just
take-
one thing, my lordship. My lordship, decree was passed by the DRT. The recovery officer has passed the order that the entire certificate amount as per the decree is satisfied. The order passed by the recovery officer is deemed to be the decree of the tribunal, my lordship, as per the statute.
Of course.
If they are aggrieved against that order, the effective remedy is an appeal before the DRT as per the statute. Instead of filing that instead of availing the statutory remedy, they have come to the DRT by filing a vexatious review petition, and due to they want to escape that application fees. They don't want to deposit that application fees because I have paid the entire decree amount. Based on appeal, they have to pay that application fees before the DRT.
What is the difficulty in returning the documents, sir?
May I,
He
lord?
has already paid, the decree has been passed, then why have you not returned?
May I take your lordship to the judgment, my lord, what has been passed by the learned DRT, my lord? Your lordship may kindly come to the judgment to their petition, my lord. They have annexed. At page 24, my lord. The relevant paragraph is at page 24, my lord.
24 of the writ petition?
24 of the read petition, my lord, what they have filed. May I be permitted to read that, my lord?
Page?
Page 24, my lord. My lord, the applicant bank is directed to file a calculation memo showing the details of the amount to be paid by the defendants after taking the amount paid during the pendency of the original application along with interest at the rate of 10% per annum, simple, so as to enable the defendant to pay the said amount, and the applicant bank is directed to serve a copy of the said calculation memo so as to enable the defendant to pay the dues of the bank, my lord. My lord, that was the crux of the judgment. We have to pay we have to file the calculation sheet. My lord, we have
Have you
filed.
filed the calculation?
Yes, my lord. We have filed the calculation
Have you
sheet.
issued the recovery certificate?
My lord.
Have you issued the recovery certificate under section 19 to subsection 22?
My lord, we have received the recovery certificate. My lord, there we have disputed the amount. We have not
No,
received
you have
that
not
amount.
received, you have to issue them. You have to issue them, na?
My lord, that we have already issued. That we have already issued.
Then why documents are not issued?
My lord, I'm stating the reasons.
Once you have issued the recovery certificate, that you are bound to issue this.
Yes, my lord, I'm stating the same thing. My lord, there was a difference. There was an arithmetical mistake of the decretal amount passed, my lord. For
Then you should have approached that particular DRT for.
Yes, my lord. We have already approached the honorable DRT. Tick again. Tick, please. We have already approached the honorable DRT in a review petition showing the arithmetical calculation. There was a mistake, and there was 94 lakhs mistake of the interest amount.
Then how could you issue the recovery certificate, sir?
My lord, that was.
If there is a dispute in the amount.
My lord.
You could not have issued.
That is what, my lord. That is what for which the review application is pending, my lord.
My lordship, let me clarify.
You are not understanding what I'm. If you had some disputed amount.
Yes, my lord.
Amount was in dispute.
My lord.
When amount is in dispute, how could you issue the recovery certificate?
Lords, they are not issuing the recovery certificate. My lords, first
It is a
DRT.
PO, my lord,
let me clarify. First, ORA DRT passes the decree. Decree taku execute karanti recovery officer by passing the recovery certificate. When the recovery certificate is passed, the decretal amount becomes the certificate amount. My lordship, see adha katha apna dekhele. Same mori read petition ne page number 32 re recovery officer ka final order ta achi joti ki se lekhi the CDR, the certificate debtor. Debtor ta certificate debtor is after issuance of the certificate. The certificate debtor has deposited the entire amount within the stipulated time. Hence, the tribunal is satisfied according to the certificate amount. The CHB is directed to file their views for further direction. After this, RC was closed. RC bond ho gala karna sabu paisa me dei delu, my lordship. Tapare, after a period of 1 year, they harassed me. They did not return the documents. and they did not prefer filing an appeal, simple they are filed the review petition. तापरे किसी judgment भी हुई and they are not returning my document.
If there is arithmetical calculation wrong, then
There is no error, my lordship.
Just a minute, sir. When you may be saying there is no error, they are saying there is an error. So when there is an error, naturally review has to be filed, not a appeal.
My lordship, टिके statute था my lordship देखो. Kindly my lordship see the statute. No, it is not arithmetical error, my lordship. जेतेबेले DRT decree टा satisfy हे जाइची, my lordship में kindly see RDB Act section 27. Yes, my lordship. RDB Act section 27, stay of proceedings under certificate and amendment or withdrawal thereof. Tar, my lordship, subsection 3, it specifically says, when the order giving rise to demand of amount for recovery of the debt has been modified in appeal, and as a consequence thereof, the demand is reduced, the presiding officer shall stay the recovery of such part of the amount of certificate as it pertains to the said reduction for the period of which appeal remains pending, my lordship. It is pendency bhitar. Next kala, my lordship, subsection 4, where a certificate for the recovery of the debt has been received by the recovery officer and subsequently the amount of outstanding demands is reduced or enhanced as a result of an appeal. Such appeal shall become final and conclusive, and then the certificate will be amended or withdrawn as the case may be. Further, my lordship, section 30, it is specifically stating that notwithstanding anything contained in section 29, any person aggrieved by an order of the recovery officer made under this act may within 30 days from the date on which a copy of this order is issued to him prefer an appeal to the tribunal. Ta tale specify karchi comments re. Even if an order is passed by the recovery officer, such an order shall be deemed to have been passed by the tribunal, and an appeal against such order shall lie to the appellate tribunal as provided under section 20 of the act.
Right.
They are simply playing, my lordship.
Right, sir.
My lord,
just unnecessarily you are taking.
My lord, your lordship may kindly have glance in section 5A of the RDB Act. 5A. 5A.
My lordship, 5A is regarding the powers.
ଟିକେ ଦିଅନ୍ତୁ ଟିକେ ମୁଁ କହୁଛି ଆପଣ ତ କହିଲେ ନା submit କରି
କାଢି ଦେଇ ଦଉଛି ଆପଣଙ୍କୁ ସୁବିଧା ହେବ। Appointment of the PO, presiding officer.
RDB rules. My lord, RDB rules 5A.
Rule.
My lord, rule.
1994.
My lord.
93.
No, my lord, sir. Amended, further amended, my lord. 5A, my lord.
1994.
It's of, my lord,
97 rule.
97.
1994 rule or 93 rule?
93.
My lord, amended on 97, my lord. Inserted on GRS 97.
97. Okay. 97 rule.
My lord.
Rule kate?
5A, my lord.
5.
My lord. Any party considering itself aggrieved by an order made by the tribunal on account of some mistakes or error apparent on the face of the record desires to obtain a review of the order made against him may apply for a review of the order to the tribunal which has made the order.
Right. Arithmetical error.
No, my lordship, arithmetic error, they have to file the review within a period of 30 days. DRT.
That is, we have also.
No, they have not filed within 30 days, my lordship.
That is that
already
tribunal will decide, sir.
My lordship,
just a minute. Whether that was filed in time or not time, the tribunal to decide.
Yes.
Why I should go.
No, I am not saying my lordship to decide. Every fact is before my lordship to examine.
Okay,
Yes.
when is that matter?
I will file an affidavit, my lordship.
Today they have taken time on the matter is listed today, my lord. Before the DRT,
The
they have
DR
taken time.
We have not taken time. I have myself appeared before the DRT today.
Taking
In the
time.
DRT, I said the same thing which I have intimated to my lordship. The DRT told me, since your read petition is
No, my lord,
pending in
DRT
the
is
High
not
Court.
Okay, then since the matter is pending with the DRT, let the
My lordship, my humble submission, my lordship, my humble submission.
for the petitioner
My lordship,
seeks to
already
withdraw the writ petition in order to pursue the matter
My
before
lordship,
DRT.
just my one humble submission, my gote jinsh. No, my lordship, unnecessary no. My lordship, unnecessary. My
I
lordship,
am dismissing it. Otherwise, if you
I
want
know,
to
my
not
lordship.
withdraw,
Mate gote
otherwise-
katha kahyak dento, then whatever my lordship will say, I am much obliged, my lordship.
ଏଠି ଗୋଟେ ସେଠି ଗୋଟେ
No,
ସେଠି
say
ଗୋଟେ-
that.
Only that they have already sold the property. When the matter is sub judice, they have sold the property, my lord.
DRT petition टा हमें file करनु, my lordship. We have come
ये
before.
कला न कर मैटर तो पेंडिंग अछि ना
We are
then why are you saying हमें करिनु से
No,
करछि
it is not amnesia, my lordship. It is
Nothing
not amnesia. Since the DRT is not
Since-
passing the order, we have come here, my lordship.
No.
And it is bank matter other than surface.
and the DRT shall dispose of the
Review petition
petition
filed by the IDBI bank, my lordship.
filed by the IDBI
But-
bank within a period of 1 month.
My lordship,
My
मतलब
lord,
सोमवार
One
जगह-
month
my
from
lordship-
today, sir. File करी.
बुझी
My lord,
my lordship,
obliged.
ମୋର humble prayer होची सोमवार जगह मते ଟିକେ time दन ଗୋଟେ written note of argument दे
କିଛି
ଦଉଛି
ଦରକାର
if
ନାହିଁ
my lordship
ଏଇ
is not
ଗପ ପାଇଁ written note of argument ଦରକାର
ଆଜି my lordship order ଟା सोमवार
Nothing
ଜମା
doing.
କହୁଛି
1 month ରେ खत्म करी
Obliged.
ହେଲା
Obliged.
within 1 month the DRT shall complete the
But my lordship, when the order has attained the finality, what
Maybe,
remains to be
sir.
examined that I
Maybe,
don't under
maybe.
order ଟା finality attend
तो जाओ
କରିସାରିଛି
ନାହିଁ ଯେ-
ତାପରେ ସେମାନେ review file କରିଛନ୍ତି
you are just people are misusing the
My lord, misguiding, my lord. Obliged.
the conduct of the bank is misleading here मैं आप statute देखେली मोर fact भी कहली
ଆପଣ ଜାଣନ୍ତୁ ସେଠି
but my humble prayer is सोमवार जाके my lordship pending रखନ୍ତୁ let my senior appear
sir
that is
senior appeal କଣ ଏଇ କଥା ମୁଁ କରିବି କାଲି ବି ଏଇ କଥା
ମୁଁ ସେଇ କହୁଛି my lordship
ମ୍ୟାଟର ପେଣ୍ଡିଂ ଗୋଟେ ଜାଗାରେ ଅଛି
ହଁ।
ସେ ମ୍ୟାଟର କଣ ଆଉଟକମ୍ ଜଣା ନାହିଁ ଆଉ ଗୋଟେ ଏଠି
my lord ସେଇ କହୁଛି ଆଜି ଯୋଉ order ଟା pass କଲେ
Will you
सोमवार
listen to me?
କରିଦିଅନ୍ତୁ yes my lordship
I am saying ସେଇ ଏଠି ପେଣ୍ଡିଂ ଅଛି ବୋଲି DRT ତାକୁ ଗଡେଇ ଚାଲିବ
My lord.
ଆଜ୍ଞା
ମୁଁ my lordship ବୁଝି ସାରିଲିଣି ଆପଣ କଣ କହୁଛନ୍ତି ବୁଝି ସାରିଲିଣି
that's why I am saying let the matter ଯଦି ସେ that order you are not happy you can come again come here
yes my lord
ସେଥିପାଇଁ ତ withdraw କରିବା ପାଇଁ କହୁଛି
yes my lord
better to withdraw
on Monday let my senior appear on Monday my lordship
Senior appear करके
खाली
change
सोमवार
करो,
रखी दे
कभी
मैं
भाई,
humble
you are
prayer
better than your senior
no my lordship सोमवार दिन एटा रख दियंतु सोमवार दिन my humble prayer my lordship सोमवार दिन एटा
ଶୁଣ, କଥା ଶୁଣ।
my senior will appear then my lordship may pass
ଏମିତି ତମ ସିନିୟର ଶିଖିଛନ୍ତି କି ଆଉ
ନାଇଁ my lordship
ଆପଣ ପୁଣି କାହାକୁ କହିବାକୁ ନାହିଁ ଯୋଉ ଯଦି DRT ରେ ଆପଣଙ୍କ ଫେଭରରେ ଆସିଲା ସେ ରିଭ୍ୟୁ କଲେ ଆମେ ମନା କରିଦେବୁ
Obliged, my lord.
yes my lordship obliged ଆଜି ତ DRT date ଦେଇ ଦେଇଛି
Here at all.
No, no, sir.
Lowering no है lowering है to you have to hear more than you speak okay खाली बोलना आता है सुनना नहीं आता तुम्हें
no my lordship my just one
I
word.
am do not speak anything पूरा चुपचाप गोटे लाइन अप करिए गोटे लाइन करला डिसमिस करिए नहले विथड्रॉ करिए कहले ହେଲା
सोमवार दिन आसो I
you
will
understand
withdraw.
the issue unless you do this what will happen the DRT will not do anything
ସେଇ
ସେ
କହୁଛି
ଧରିକି ବସିଥିବ
ନା ମୁଁ
ଆଣ୍ଟି ଗଡେଇ ଚାଲିଥିବ DRT ତାଙ୍କର
my lordship ଆଜି DRT ରେ ତାରିଖ ଥିଲା ଆଜି DRT ଗୋଟେ ଡେଟ୍ ଦେଇଛି
କେବେ ଡେଟ୍ ଦେଇଛି
ସେ ଡେଟ୍ ଦେଇଛି after 2 weeks my lordship
after 2 weeks ନା
2 weeks ଆପଣ सोमवाର
ଆରେ
ଦିନ ରଖନ୍ତୁ
ଶୁଣ ମୋ କଥାଟା ଶୁଣିବ 2 weeks withdraw କର DRT ଯଦି କଣ ହେଲା DRT order is suppose in their favor anyway you will
but
come
my lordship I don't know I have not been told by my senior if withdraw सोमवार आज जो let my senior
ହେଲା ମୁଁ dismiss କରିବି
no, my lordship my humble submission let my senior is not here
unnecessary you are just wasting time you want to withdraw or I want to I will dismiss tell me which is comfortable to you withdrawal comfortable or dismissal comfortable to you but କରିବି ତ dismissal
my lordship my humble submission is let the matter come on Monday if my lordship will say I will withdraw on Monday my lordship
Your lordship may kindly have a glance if they have.
the matter come on Monday my lordship
he's scared of his senior
My lord, but he is arguing on the matter. He is,
Kitchen. He's good. He argues well.
my lord, he is arguing the
But
matter.
only
He never
he
allows
has the problem of overtargeting. He never he doesn't know where to stop.
My lord, my lord.
That is the only problem. Otherwise, he argues very well. Problem is he doesn't break. Okay, Monday. ठीक है Monday. Next. Monday रख दे.
My lord, they are taking time on the
ठीक है
basis.
sir.
My lord,
संतु अब आपन को भूल अछि तांगरे भूल अछि देखिए कार भूल अछि सेते
my lord.
actually better ଅଛି ସେଟା ସରିଗଲେ ଜଣା ପଡିଯିବ ତାପରେ ଆପଣଙ୍କୁ ବ୍ୟାଙ୍କ କୁ ଲଗେଇବି cost per day 5,000
My
ସେତେବେଳେ
lord, if at all it's permissible, I will bow down by your orders, my lord. Will
Yes.
bow down.
ଏବେ ସେୟା କରୁଛି ଯୋଉ ଯିଏ ଡକୁମେଣ୍ଟ ନ ଫେରେଇଲା per day 5,000
My lord, I'm already filed my counter, my lord, in this case. And there's
କାଉଣ୍ଟରରେ
a,
କାମ ସରିବନି
no, no, my lord, will,
once convince ହେଇଗଲେ ଆପଣଙ୍କ because of your
yes, my lord, if at all your lordship
things
get
are,
convinced that there is a flaw in our side, we'll bow down by the order what your lordship passes. My lord, absolutely, my lord.
ଆପଣ ରେଡି ହେଇଥାନ୍ତୁ 5,000
My lord, every day we will bow down, my lord. If at all,
RBI guideline ଅନୁସାରେ ଆପଣ କରିଦେଇଛନ୍ତି already PNB matter ରେ
ସେ ମେଲରସିପ କାଉଣ୍ଟରରେ ପୁଣି କହିଛନ୍ତି
ଆଚ୍ଛା, Indian Overseas
ଗାଇଡଲାଇନ
Bank।
ଆମ ଉପରେ ଲାଗୁ ହବ
କିଏ କହୁଛି
ସେ
ଲାଗୁ
କାଉଣ୍ଟର
ହେଇନି?
ଲେଖିକି
ମୁଁ କେମିତି ଲାଗୁ ହେଇନି ଆରବିଆଇ ଗାଇଡଲାଇନ ଦେଖିବା କେମିତି ଲାଗୁ ହେବ
my lord, at
ଆପଣ
this
ଆପଣ
stage,
ଆମେରିକାନ ବ୍ୟାଙ୍କ
no, my lord, it's not that this misrepresenting, my
ଫେଡରାଲ
lord.
ବ୍ୟାଙ୍କ ଅଫ ଆମେରିକା
My lord, completely misrepresenting. We have stated that as because the review is pending, RBI guidelines will not have an application because the review is
ନା
pending.
ରିଭ୍ୟୁ ପେଣ୍ଡିଂ ଗଲେ ଆପଣ ଯଦି ଟାଇମ କିଣିବା ପାଇଁ ରିଭ୍ୟୁ ପେଣ୍ଡିଂ କରିଥିବେ ଯଦି
My lord, no, we don't want to buy
just to
time. We
avoid the
wanted
time
that
ରିଭ୍ୟୁ ଫାଇଲ କରିଦେଇଥିବା
No, my lord, we are pressing hard to be decided.
ମୁଁ
my lord.
ଦେଖିବି ଯେ ସେତେବେଳେ ମୁଁ ଦେଖିବି
Because there is a due of public money due, my lord. It's not that.
ପବ୍ଲିକ ମନି ଡ୍ୟୁ ଯେ
My lord,
କେତେ
had it been-
ଆପଣ ତ ଦେଇ ସାଇଲାଣି ପବ୍ଲିକ ମନି ଡ୍ୟୁ କୋଉଠି
No, my lord, there is a due because there was a mistake in the arithmetical mistake.
arithmetical mistake ତ ରେଜ କଲେନି
We have raised it.
ରେଜ କଣ
Already admitted, notice has been issued. They have already filed the counter before the DRT.
Okay, ठीक है Monday
Only it is.
okay next
My lord,
next
56.
56 56
I'm clear, sir.
Yes.
In this case, my lord, petitioner is the father of deceased owner of the vehicle, my lord. The vehicle finally, my lord, no source of income, my lord, the
Sir, এটা a prayer কাম দিয়েনি no source of income I have no money to pay all these things are not it is not entertainable at all
Yes,
the paper OTS,
it is not entertainable
pays for OTS, my lord.
ତ କେତେ ପଇସା ଦେବେ କେତେ amount ଅଛି total
ଏଥିରେ ତିନିଟା ଚାରିଟା ଡ୍ୟୁ ସେ
କେତେ amount ଅଛି
8,30,509.
8,30,509
finance, my loan was financed, my lord, on
ଆପଣ କେବେ ଦେବେ
November 2023 ରେ finance ହେଲା. The ଗାଡି was delivered. The vehicle was delivered on November 23, my lord. Thereafter, my lord, in the month of January, my lord, the owner of the vehicle died, my lord. My lord, that I have given the death certificate, my lord.
People not here all this
13th one.
No, if they want to keep the asset, they have to take liability. Otherwise, they can surrender the vehicle. So two things they can't do. We'll keep the asset also, we'll not make the payment.
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ ପଇସା ଦେଇ ଦିଅନ୍ତୁ asset ରଖନ୍ତୁ ନହେଲେ ଗାଡି ଦିଅନ୍ତୁ ଆଉ କଣ କରିବେ
There was a for
That's why they propose the
financing
48.
bank, my lord, there is a policy, my lord, loan protection policy.
sir loan protection policy କଣ
ଅଛି
Kachi-
there.
kachi କହିନାହାନ୍ତି।
କଣ ସେ
Insurance-
policy
So
Loan
you go to
protection
insurance,
policy.
they-
କୋଉଟା ସେଟା ସେ policy ଦେଖାନ୍ତୁ
ସେଇଟା ସେ ଯେତେବେଳେ ଫାଇନାନ୍ସ ବ୍ୟାଙ୍କ କରୁଛି ବ୍ୟାଙ୍କ
କୋଉଠି ଅଛି ସେ policy ଦେଖାନ୍ତୁ
ଏଥିରେ ସେ ଗୋଟେ ଦେଇନାହାନ୍ତି ପଲିସି ଗୋଟେ ଦେଇଛନ୍ତି ସେ ଯାହା ଏଠି ମେନସନ ହେଇଛି
protection policy ଟା କୋଉଠି ଅଛି ଦେଖାନ୍ତୁ
ଗୋଟେ ହେଲ୍ଥ ଇନ୍ସୁରାନ୍ସ ପଲିସି ଗୋଟେ ଏଥିରେ ଅଛି ସେ ଦେଇଛନ୍ତି ଫ୍ରି ଅଫ
sir health insurance policy is different sir
ଡିଫରେଣ୍ଟ ସେଥିରେ ମେନସନ ହେଇଛି ବଟ୍ there is a loan protection policy while
Where is that policy?
bank finance
ଆରେ ସାର୍ ଦେଖନ୍ତୁ ତ ମତେ ସେ
but
policy
the,
ଖାଲି କହି ଦଉଛି
that is the agreement, my lord, agreement is not
କୋଉଠି ସେଟା ଦେଖାନ୍ତୁ ସେ agreement ରେ
that is
ହଉଛି
with the bank, my lord, that is all the documents with the bank, my lord. The private bank, that is why, my lord, petitioner is not able
is there any
to
loan protection policy
It's a health policy, there's a mediclaim he has taken.
mediclaim.
So mediclaim, for hospitalization, there's a policy he must have taken from the other insurance company.
hospitalization is different no?
Hospitalization different, my lord. But
Yes,
while
hospitalization-
sanctioning the loan, my lord, the bank is there, my lord, to protect
sir
the.
ସେମିତିଆ ଗଲେ ତ ଲୋନ କେହି ସମସ୍ତେ ନେବେ ଆଉ ଚୁପଚାପ ଭାଇ ପ୍ରୋଟେକ୍ସନ ପଲିସି ଅଛି ଯାହା ପଳା ପଇସା ପଇସା ନ ଦେଇ ପାରେ
ସେ
ଚଲେଇଲା
ଯଦି death ହେଇଗଲା accidental death or any
accidental death ଲୋକ ସେମିତି deliberately ବି ଦଉନାହାନ୍ତି
ଅଛି ତାର protection policy, that agreement is
ଆପଣ
there.
ନେଇକି ଆସନ୍ତୁ ସେ policy ମୁଁ ଜାଣିନି କେମିତି
ସେଟା ତାଙ୍କ ପାଖରେ ଅଛି
Insurance, who is the insurance company also is not disclosing.
the bank finance bank with that
sir bank ରେ policy ନଥାଏ
agreement ଅଛି agreement ଅଛି agreement
ଦେଖାନ୍ତୁ ନ ଦେଖିଲେ ମୁଁ କେମିତି ଜାଣିବି?
Agreement
You have to show, sir. ନ ଦେଖିଲେ ମୁଁ କେମିତି
My
ଜାଣିବି?
submission for Lordship, while the bank sanctioned the
Sir,
loan.
I am agreeable to everything you say, but show me the document. Document ନ ଦେଖିଲେ ମୁଁ କେମିତି ଜାଣିବି? ଆପଣ ଦେଖାନ୍ତୁ.
Document is with the bank,
ଆପଣ
if
ଟିକେ
the agreement will be produced, I will file a miscase, my lord, for production of agreements for Lordship, my lord. The private Lordship knows, my lord.
Why I will get the loan agreement.
Okay, sir.
No, loan agreement is not given.
He'll get the.
I will get the loan agreement, I am saying.
Okay, land council for the bank to get the loan agreement.
Produce the loan agreement.
Not to produce the loan agreement because they put on at least the matter on 1st July. Hala? Loan agreement नहीं किया सकते. Next.
Item 58.
Lordship, would be to-
First
Lordship,
July.
huh?
First July.
1st July.
July.
58. 57 क्यों time?
57. 15. Mr. B. Pradhan, opposite party.
अच्छा, entry order करें.
ନା ସେଟା ସେ କହିଛନ୍ତି।
Entry order करें. 58.
58.
My lord, notice was issued. Noting is there. AD not returned back.
58 रे Mr. Pradhan, today morning Mr. Bidadhar Pradhan seeking time for because he has entered appearance for OPU2. ଆପଣ କହିଥିଲେ ଯେ ତାଙ୍କଠୁ
58 ଟା ନା
57 ସେଟା
ଆପଣ କୋଉ ନମ୍ବର ଅଛନ୍ତି?
200.
58. OP number 2 କିଏ?
Nagad District Central Cooperative.
Out next.
ଆଉ third ହଉଛି ଛାମୁଣ୍ଡିଆ society credit service society
Goniya branch.
ଗଣିଆ
So what do you want? କଣ issue କଣ?
My lord, issue.
allow time after filing count.
Okay, land council. What is your name?
Anupama Mishra.
6 time on behalf of OP number 2 and 3. To file the control, this is the matter on 16th July. 16th July. Yeah? Next.
59.
59, your lordship, I am in VC, your lordship.
We are for the state.
I am for the respondent, your lordship.
For the opposite party.
ଏଟା 138
I am for the opposite party, your lordship.
Who is for the petitioner?
They usually appear on VC, your lordship, but constantly, your lordship, since the listing of this matter, your lordship have been directing them for deposit. But till date, there is no deposit and nothing, your lordship. No way the case is moving also, your lordship.
Nobody is appearing.
No, your lordship, no one.
Polai the advocate.
Last occasion on 20th of March, your lordship had directed.
So RK Polai, whose name just non appears for the petitioner at the time of call. On the earlier occasion also 24/1/2024 non appears. Why is it put answer question? Well, let's give one chance. Petitioner has not appeared in the matter. This is the matter on 9th July.
Obliged, your lordship.
9th July.
Item 60.
No, President, 138 matter, my lord. And next one is the lower court judgment. Check
Who is
amount
the
is
opposite party?
check amount is 20,000. Award amount is 33,000. Petitioner is ready and willing to pay the check amount entire, my lord. Already has deposited in the appeal.
Total amount kete?
Technical amount is 33,000, my lord.
33,000.
Check amount is 20,000.
Total 33,000 देवार अच्छी. तो दे दिया तो खत्म. Land council for the petition, your petitioner.
Okay.
Petitioner has undertaken to pay rupees 33,000.
33 ticket reduce because of check amount khali check amount 20,000.
Modify career chance.
20,000 check amount se already be dei sari 6,000. So that 20,000 plus 20,000 plus 6,000 26,000. No 18 mas so say 26,000 because of 6,000 dei sari in appeal period re au ko 600 20% ଆଉ decretal ନା କଣ ଆଉ check amount 20,000 so 26
25,000.
33,000 total amount.
decretal amount
Interest.
डिक्रीटल अमाउंट जो ऑर्डर टा कंपनसेशन अमाउंट
डिजिटल अमाउंट आपण 20,000 आपण 6 ଦେଇଛନ୍ତି ଆଉ 6 ନେଲେ ଗଲା ହେଇଗଲା ପାଇଗଲେ
एंड से ता बड़ भाई याठारो सब जाक पैसा नहीं सारी चंती हैंड लोन ता बड़ भाई सबटो पैसा नहीं सारी चंती मैं सही से
ସେ ସବୁ ମତେ ଦେଖାନ୍ତୁନି ୱିଡୋ ୱିଡୋ ମୁଁ ଆପଣ 33,000 ଦିଅନ୍ତୁ ନା ମ୍ୟାटर କ୍ଲୋଜ କରନ୍ତୁ ନହେଲେ କନସିକ୍ୱେନ୍ସ ଦ petitioner to pay the decretal amount within a period of one month.
Yes.
1 month from today. Accordingly, the what is this? The criminal revision is disposed of. That's it.
डिक्रीटल अमाउंट मिलर
Of course.
मिलर बिकॉज़
दया करछदी
नहीं दया नहीं बिकॉज़ ऑफ ये बॉयटा भी
in the opposite party is directed to bring to the notice of the court if if the said amount is not paid within the aforesaid period, the opposite party is directed to file an application before the court regarding direction from the court.
Excluding Lord the amount which has already received Lord, which has been already received Lord.
Excluding the amount which has already been deposited before the
at the time of appeal Lord.
at the time of
সেটা স্যার মতে মিলিনি তাকর কোন টেকনিক্যাল ভুল আছে কিন্তু ডিপোজিট করতে মো অ্যাকাউন্ট আসিনি
সেটা নেই যে আপন
সেটা মানে আসিনি ফর দ্য টিল টুডে
balance it.
the complaint on receipt of
এটি জায়গায় আমরা ফাইল করব in the meantime the petitioner to approach the court below to take the what that the deposited amount, huh? You take it from there and the court shall release the amount, the court below shall release the court.
JMFC just for order. JMFC just for order.
In favor of the opposite party.
Once
Open proper application.
in one six number me Lord.
Upon proper application, the deposited amount. Rest of the amount will be paid within 1 month.
মানে 16 কেস না 41 অফ 208
160 case. In
41 of 18
here.